25th.
On 25th?
Because in between the selection matter, little bit.
I
have taken consent.
I can call it next week.
No, I have taken consent.
No, that's all right, sir. But 25th is order 41 matters. Actually, to tell you the truth, Honorable the Chief Justice is very worried that these matters are not being taken up. So that is why it has been given to me in addition to the bench. So, yes, you have taken.
May I suggest one?
Yes, yes.
এটা 25th ক্লাস যেহেতু মু আপিয়ার করে সারিলানি
আমার ট্যাবলেট আপিয়ার করছে
আজ্ঞা এলসিআর আসলে
give a copy in the meantime.
All right.
এলসিআর আসলে শুনি দেলে ফাইনালি বি হেইও
ନାଇଁ ସେ ସେଇଥିରେ ଶୁଣିଦେଲେ କହିବେ ଆପଣ ଯୋଉ ଇଏରେ ଆସୁ କଣ
ଆଜ୍ଞା ଏଲସିଆର ଆସିଲେ ବେଟର ହବ
requests for adjournment is made on behalf of the appellant. The respondents na jane
ଦି ଜଣ
respondents have entered appearance through caveat, being represented by Sri Bhaskar Chandra Panda, as consented by both parties. List this matter on 25th. We commencing. So we commencing like 22nd. We commencing 22nd July.
I wish to argue this case before your lordship.
Sir, it will be an honor, sir.
Last case before your lordship.
Sir, it will be a great honor for the court, for the privilege to hear your lordship. I have the privilege of assisting you as a lawyer. Copy of the appeal memo has already been served upon Sri Panda.
One more thing, another matter. Already argument was completed, judgment has been reserved. ମୁଁ ଦେଇ ଦେଇଥିଲି ଗୋଟେ ଆଡିଶନାଲ ଦେବି ବୋଲି ଭୁଲି ଯାଇଛି
I am pardon to mention your lordship ERBCR 27 of 2024 your lordship but mention करथिले before your lordship
କିନ୍ତୁ ଯେହେତୁ ଦିଅନ୍ତୁ
all the cases will your lordship मैं direct evening को wide जोड़ के चाहूचे we are ready for that
ଦିଅନ୍ତୁ
transfer pardon to mention my lord I take weekly
yes
weekly list item 38
item
38 hearing matter my lord so
hearing or hearing order 41
no my lord hearing
item कितने कर
38 my lord
sir 38 is under
I am for the appellant
weekly list quota yes
I Hon'Ble got the file my lord misplaced elsewhere my lord that's why I am
2003 matter sir
yes my lord I know it my lord my file misplaced elsewhere my lord that's why I am I want adjournment my lord in my chamber my lord what is going on for that reason
I'll call it next week then
1 week after my lord but chamber
requested by learned counsel to the appellant is this matter in the week commencing 15 July.
May I be pardoned to make a mention, Your Lordship? Your Lordship, item 49 of the weekly list. It's a second appeal here for the appellants. Your Lordship, the LCR is not on record. If I may pray to post it for the next week and the LCR may be called in the meantime.
Item 49.
Yes, Your Lordship. RSA 300 by 2011.
Let it reach.
Okay.
LCR may not be required of you.
Pardon to mention, my lord, item 7 of the supplementary list.
Yes.
My lord, on behalf of Mr. Bimbisar Das.
Item 7.
Yes, my lord, of the supplementary list.
Yes.
My lord, on behalf of Mr. Bimbisar Das, as Mr. Das is suffering from viral fever. So kindly
adjournment is made on behalf of Mr. Bimbisar Das, who is suffering from fever. Let's this matter next week. Yes.
Right. My lord, Lordship, I'm taking pardon for mentioning this bail matter. Yes. Lordship, this matter was listed in the month of January. After that, the matter has not been listed, Lordship. It's 12049 and 12051. Same FIR tied up matter, Lordship.
Have you asked anybody to file a memo on your behalf?
Yes, Lordship.
Right. Yes, today itself?
Yes, Lordship. Yes, Lordship.
All right. So, allow next week. You can come next week.
Yes, Lordship.
Yes, Mr. Mahapatra.
Item 15, your lordship.
Item 15 of which list?
supplementary list, your lordship. TRPC number 84 of 2018.
Yes,
May I pray, my lord, it may be taken up after 12.
after 12. All right. Place this matter on 16 July as paid for. Yes.
Pardon, my lord, I'm little late, my lord, sir. Yes, 6 years ago recruitment, my lord, sir. So, it's of 16, my lord, appointment engagement not given, my lord, because of nativity, my lord. So, this matter.
Yeah. Yeah, allow for
Right. Item 15.
Yes, yes. It will come on 16 July.
My lord, interim order may be extended. Your
Interim order to continue.
deep low.
Supplementary list item number 1. May I please illustrate? I first amendment. I have 165 or 24, my lord.
What amendment do you want?
Inadvertently, my lord, we have mentioned in para 3 and 5 that I am having a minor son. That may be
Deleted.
deleted. Para 3 and 5.
I do 165 for 2024. Prayer for adjournment is made on the ground that certain incorrect facts have been inadvertently stated in under paragraph 3
and 5,
and 5
my lord.
of the transfer application. There is the amendment proposed to be incorporated. The same appears to be formal in nature. As such, the prayer for amendment is allowed. The consolidated
Filing.
transfer application is filed in the court. Same be kept on record. Yes. What is this matter about?
My lord, here the wife is the petitioner seeking transfer of CP filed under section 9 by the husband before Family Court Raurkela to Civil Judge Senior Division Champua, my lord. The ground for transfer is that distance is around 140 kilometers.
Right.
And second,
Take notice. Issue notice to the opposite party by speed post, fixing a short returnable date. The requisites be filed by tomorrow peremptorily. Place this matter on 23rd July.
आइए सर
आइए adjournment, huh? Adjournment.
स्टे में भी
आइए
स्टे में भी
ना adjournment. No stay.
Item number 2.
Item 2.
Well, the petitioners are working as regular primary school teacher, my lord. They are claiming for anticipation of a regulation from 17 to 2014 in view of the ratio decided in Dhananjay Charan Day case, my lord.
These are all individual petitioners.
No, my lord.
Sabutre Hon'Ble Achanti.
Yes, my lord. The lordships have passed similar order, my lord.
I know, but you do the exercise.
My lord.
Take my order.
Correct. Yes, my
Make
lord.
necessary corrections and give it.
Yes.
There are two different types of orders. In a single individual petitioner, his representation already submitted will be considered.
Yes, my lord.
But insofar as others are concerned, all of them have to
Make separate representation.
representation.
This is with respect to that joint application.
All these matters are the same.
Yes, my lord.
All the matters, sir.
All right.
Item number 3.
Yes, Mr. Das, who's opposing you?
Statement.
Only state.
Yes.
All right.
Now, my lord, the first part of my prayer has already been covered by the judgment, recent judgment in that Ashok Manti's case.
What is your prayer?
My lord, my prayer is the retired employee.
Selection
The reader scale from 1/11/1989. Because on completion, I have joined in 76 and I have PhD degree. Therefore, 8 years plus 5 years, 13 years after I am entitled to reader. I have given the first part of the relief. That means the senior, UGC scale of pay.
with effect from 1/11/89.
86.
You have already got it.
Yeah, first part is got. The reader.
That part you can drop.
Yes, madam. The second, actually, the contention is now with regard to second part. I have started service in a government institution.
Oh, so you wanted by counting from 15 and
I have to get, if they are opposing it to the extent that Rule 6 of the Pension Rule 1981 of the added institution doesn't cover the service of a government institution. The vice versa is available in the pension rule, our government rule. This is not permissible here. So therefore, I want to submit, my lord, an alternate that I have 10 years service in the government. So they are to pay
minimum
benefit and the added period I am getting. So let them also consider that. This is a very old man. I could not file a rejoinder also to this section because he is unable to move.
No, what do you want? If you want, I can dispose of. Otherwise,
These are the two prayers.
Yes.
My lord,
so
consider.
the first part, he fairly submits that he has already got the relief.
No, but not reader still I have not got it. I will get it because of the judgment of that Ashok Manthi case.
My lord, we
I have
have
get
granted
the
the
first
benefit.
part. There are two parts, my lord. First is the UGC scale of pay. The first is the senior lecturer, thereafter the reader. I got the first part, senior lecturer.
Okay.
But the reader I have not got it. I have to get it after 13 years because I have PhD degree.
You are relying upon that judgment of.
A recent judgment my lord have given. There are many other judgments, but the recent judgment covers everybody. That Ashok Manthi's case.
So that his prayer for that reader scale can be considered in light of Ashok Manthi.
My lord.
We have
If Ashok Manthi has not been set aside in the meantime.
Even if irrespective, now even Ashok Manthi has not got anything. But here in the case, I have been given the benefits without deducting that 5 years. So now after that, I am entitled also from 1/11/89. By that date also the amendment has not come. That amendment 7C.
Is it 80?
it has been made retrospective.
In 94, that gave it
Retrospectively, yeah?
that is.
Retrospectively.
Yes.
My entitlement is much prior to that.
Achha.
So in that score also I have to get it, but because the judgment is there, I need not to bother from other things. This
So,
is the
so what do you suggest? Both of them? Should I pass a full length judgment or?
I don't know pass because his age is now, my lord, kindly consider that.
80 ବର୍ଷ ଉପରେ ହବନି? 66 ରେ ଯିଏ join କରିଥିଲେ ଆମ ଜନ୍ମ ପୂର୍ବରୁ
2009 ରେ 70 ବର୍ଷ ହେଇଥିଲା ତାପରେ ଯାହା ହେଇଥିବ
2009 ରେ 70 ହେଇଥିଲା ଆଜ୍ଞା ବୁଝନ୍ତୁ ଆଜ୍ଞା ସେ
ବଞ୍ଚିଛନ୍ତି ସେତିକି ହଉଛି ଜାଣିଛି in the death rate. Because his son is a judicial officer, he is instructed.
Okay. So let us hear it then.
ଆଉ hearing ଏତିକି ସାଥି ହଉଛି ଯାହା ବଞ୍ଚିଥିଲା ଗୋଟେ ଅର୍ଡରଟା ଯାଉ.
Okay. My lord, what I submit, my lord. Because we have disputed the prayer in this original writ petition, my lord, on the basis of some factual aspects also.
Yes.
So, lordship may keep it reserved. A full length judgment may be rendered in view of that Ashok Manthi case, my lord.
All right.
But on the basis of the factual,
that will be taken into. I mean, that will be reflected in your judgment. You are not. I never write that the state has considered. I never write that.
No, I'm not also making that submission.
That's it. I have not filed a rejoinder. In the note, I will clarify that.
All right. Hearing concluded. Judgment reserved. Parties may file the note of submissions and memo citations, if any, within
1 week.
Within a week.
My lord.
All right.
I don't know, item 4 that will come next week. Mr. Biswal was arguing the matter last order, your lordship directed to produce
For
the
that,
report.
I also seek for 3-4 days time because I talked to the director, the newly appointed director. He has promised that within a period of 7 days, I will trace it out and submit. Your lordship had made it mandatorily to be produced today.
14/5/24 order.
Yes.
Due to pendency of this case.
18/6, your lordship had directed.
It's a 2012 matter, Mr. Das.
Yes, because of the fact that it has become so old, they could not trace. Now the new.
What happened? What is happening to their records? Only because by efflux of time, all records are going away.
No, they are finding out the director.
Another thing is that there is a central record room. There is a central record room.
Yes.
Say, not central record room. So they are not.
He has promised me to make this submission. Your lordship, undertaken that he will be tracing out.
As requested, list this matter next week. The previous order be complied with positively, failing which appropriate orders shall be passed.
I don't know, 5 next week, next Tuesday.
Next Tuesday.
My lord, in this case, my lord,
Yes.
the last occasion, my lord, on 25th, my lord, government council, my lord, filed my additional counter affidavit, my lord. So I have already, my lord, instructed to the, my lord.
The date of your engagement to relate back to the date on which the Board of Secondary Education issued notification declaring equivalency of DSC course with CT. Isn't it?
Equivalent of basic course in the year 2012, my lord. The affidavit is the government has filed, my lord. But actual, my lord, facts remains, my lord, since in the year 2005 onwards, my lord. They have declared government had declared the diploma in special education equivalent to city. And they have been giving appointment, my lord. they have been giving appointment, my lord. But despite of that, my lord, they, so far as the.
It was a fresh appointment. It was a fresh appointment. Prospectively, they have granted you the benefits.
It is prospectively, but since it was already decided, and the year 2005, my lord, they have given appointment. And from 2005 on.
You are required to file an affidavit, Mr. Das.
Yes.
Affidavit filed. They have filed.
No. I don't know. Look at order dated 21/2/2023. 21/2/2023. Almost 1.5 years ago. I'm reading out the as directed, London State Council has obtained instructions with regard to the candidates who, according to the petitioner, were granted similar benefits as claimed by him. London State Council shall also obtain instructions as to why the petitioner's engagement as Sikha Sahib shall not relate back to the date on which the Board of Secondary Education issued notification declaring equivalency of BSc course with CT. The same shall be filed by way of an affidavit. There also an affidavit file करना देंगे.
ସେ କରିଛନ୍ତି ଲାଷ୍ଟ ଅକେଜନ ମତେ
या पर affidavit को file करें.
ହଁ ପରେ 25/6/24 ରେ ଗୋଟେ ଦେଇଛନ୍ତି affidavit.
Okay.
Last
Additional counter.
Additional counter affidavit I have received on 25/6.
Yes. What do they say here?
They have
So let us hear the matter, Mr. Das.
Some other day.
Some other day.
I don't find that additional affidavit in the.
Cool. It is there in record. You have already filed it. You filed it on. You filed it on 15/3/2023.
Tomorrow your lordship may call, let me find out.
They served on 25/6.
Therefore tomorrow.
Therefore, my lord, next week, because my lord, I have to file a response to that, my lord.
And also you have taken 1 year 3 months
No,
time.
my lord, I will not fix date, my lord.
Tale asu next week asu apne in the meantime jodi file kariya katha kariyo.
My lord.
But serving copy on them other before.
Yes, my lord. Prior to filing, I will file.
Satpathy Leonard, counsel for the petitioner, wants to file a response. Wants to file his response to the additional affidavit filed by the state. Let's this matter next week. Affidavit response, if any, be filed in the meantime. Yes.
Item number 6.
Both matters same.
Same, man.
Yes.
Item 6.
This was partnered, but the PS is that matter. In advertisement issued in 2013.
Just the procedure adopted for selection of PH candidates of Kendrapada district has been delayed. The court would like to know the basis for adopting such selection procedure. Learned State Council shall address the court on this issue. Yes.
I am prepared with the submission, my lord. But in written form, my lord, I do not have any.
All right. Let us make a submission.
Just like yesterday's case, my lord. Interlocking of the
Interchangeable.
Oh, that horizontal and vertical
I
reservation.
stand corrected, my lord. Yesterday I made a strong submission.
Right.
With respect to their vertical and horizontal.
Social and
Yes,
special.
social and special.
Special is horizontal.
Yes.
Social is vertical.
Vertical.
So let us hear it.
Yes.
Yes, Mr. Rao, place it. Please place the facts. You have a date chart.
Yes, ma'am.
Advertisement was published. 168 vacancies in Kendrapada district. 5 seats reserved for each category. 2 posts reserved for locomotor disability.
Then petition is disability for PHOH.
PHOH.
And the TGT arts is the reserved post. And as per the serial merit list, my provisional select list, the Achutana Samal was the first person for PHOH category. For TGT arts, my lord. And he was found less than 40% disability.
Clear now,
But the provisional select list, my lord, kindly see the provisional select list in page 22 page, unless 3, my lord. But the
where is your name?
My lord?
Where is your name?
My name is serial number 5, my lord.
Serial number 5. Madhusmita Samal.
That is the
PHOH 40%. Yes, Kola.
40%, my lord.
But what is your category? Social category, SCBC.
SCBC, my lord.
Right, then
Achutana Samal is the candidate, the serial number 1.
Serial number 1, yes.
He was selected for the in a fast my lord.
Yes.
But his found disability is more less than
40%.
10 below 40%. Therefore, his standard was cancelled. Subsequently, there was Ranjan to Madras as my lord, serial number 4.
Yes.
He was found with the double candidature. That is cancellation. He was candidature was cancelled. But my name was not referred to for selection list or medical board to. That is the question, my lord. But the point raised by the state is that due to ban order, no second provisional list was published. Therefore, your name was not found place in provisional list. In provisional list, that is the merit list, my lord. Provisional list, no, my name is not found place. Therefore, your name was not forwarded to the selection list. But my responsibility, but after the ban order, that is number of steps was taken. Numbers of persons was sent to the medical board, and one Madhu, there was the he was also not Satapatma Das. He was not in provisional list, but he was selected after the ban order. After interchanging my post.
She is not a PH candidate.
He is a PH candidate, but he was posted to apply for Sanskrit. I am TGT Arts, my lord. The post PH was category was reserved for. And
let us see the advertisement then. Let us see the advertisement first.
Running page 76, man.
Running page
76 in counter 41, man.
Kota column, Mr. Rao, kete?
Counter 41, but my running page is 76. But not mass in this.
No, आपको annex और kete?
One is counter annex.
Counter annex kete A by 3 ना B by 3 ना कौन?
Sir, in our counter, my lord, actually we enclosed a copy of the complaint petition as well as the so cause reply what we have filed, my lord.
So before the state commission.
State commissioner. So running page 41, my lord.
Running page 41. In counter.
Running page 41 is your show cause affidavit. I want to see the advertisement, the breakup of the different categories and the posts of different disciplines. That is what I would like to see.
That is what it is available at page note, running page 41 of my. That is so cause affidavit. Annexure A by 3. It starts with page number 9.
Yes.
Of my counter. They are running page 41, my lord.
So what does it say? It is just a show cause. It is just a show cause.
No, this so cause was actually filed before the.
That's right. That's right. But I would like to know what was the advertisement? What is the breakup of the vacancies available under different categories?
That is what it is available. Sorry, madam.
Page
no 41 is.
41 लिखे सेटा ना 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 आप पेज मार्क मिस होची आउट को पेज
I filed it. 41.
You are showing the thing, but it is not there.
My lord, that is a part of. No. I think, my lord, that is the last 2 pages of our counter.
Okay, that is 72. देखो annexure C by 3 रे वाला
Annexure
C by 3. We are talking of Kendrapada.
Kendrapada.
Kendrapada. Kendrapada is at serial number 17. TGT PCM 12. TGT CDZ 0. TGT Arts is 32.
32.
So these 32 posts are, I mean, these are the relevant posts.
My lord, thereafter, my lord, classical.
Classical 23.
Yes.
0. So Hindi economic 68. PT 33. You are not concerned with Hindi or PT.
Because, my lord, as per the allegation of the petitioner, my lord, one person belonging to OH category of Sanskrit, classical, my lord, she has been adjusted against that particular.
So total posts is 168.
168.
168. तार कितने परसेंट होगा पे देखिए?
3% है 5 post is reserved.
तुरंत कोड लिखा है सी PH कैटेगरी परसेंटेज टा पाए थी वो.
सर अच्छी सेट है.
ये तो इतने
Your lordship may come to physically handicapped. This with respect to the relaxation of age, my
lord. 10 years वाला.
Then they said how 5th line, right?
हाँ.
Then with respect to the last part, para number 2, last word pipeline, my lord. Exchange F, SC, ST and physically handicapped candidates should have registered their name with that much, my lord. But with respect
नहीं
to
रिजर्वेशन डाला पैराग्राफ 3 जोटा की अधा कटि ଯାଇଛି the provisions of Odisha last line टा रखंतु Odisha reservation and vacancies in posts and services act and other reservation as prescribed by government from time to time shall be followed up to 33.13% of the so ଆମର ସେଇ जो PS ର total percentage ଟା କେତେ reservation
3%, no, of
କେତେ?
the 3%.
3%
3% of the
Three or
total
four?
seat. The one
No,
listed,
3%.
3%. PWD category.
So 3% of 168 comes to
5 posts.
Five. 5 posts. 5 posts total.
Yes.
It will be spread across the
Across the different categories.
different disciplines.
Disciplines.
Alright. Not that प्रत्येक फिरे 3% କରାଯିବନି overall କରାଯିବ.
Yes.
Alright. And irrespective of the social category to which you belong, you will have to first qualify on merit in the category against which you have applied, which in your case is TGT Arts.
Civil charge.
So TGT Arts, there are 32 posts.
32 posts, that is one post.
32 post ଭିତରେ ଆପଣ ଆସିବା ଦରକାର.
One post which that is the reserved for PSOS category.
କାହିଁକି କୋଉଠି ଲେଖା ହେଇଛି ସେଟା
ତାଙ୍କର ଯାହା ସେମାନେ calculation କରିଛନ୍ତି.
କୋଉଠି ଅଛି ଦେଖେ ଆପଣ you have given a calculation I think here the provisional selected of PH category was published in the following order Achyutananda Samal, Sasmita Das, Sanita Samatra, Surendra Behera, Sheikh Hisamuddin.
Annexure 7, 20 page 29 10.
Yes.
In the category of PH vacancy, position of contract teachers for the advertisement of June 2013, my lord, first table. That is the PGT Arts, my lord, middle. That is the OS category 1 and the HI category 1.
Since there is a separate category for classical teacher, how could a person from that category be adjusted in this category? This is the question.
As per the commissioner has been clearly passed the order, my lord. The career provided the question, my lord. The vacancy page 19, the order of the commissioner, my lord.
One
The
thing
vacancy
to
now
add
that field of
one thing to add that, my lord. Lordship may come to page that is 16.4. It is annexure 6 and annexure 7, my lord. 16.4 2016 and 25.8 2016. But your lordship just now put me that question. That category wise breakup also it is available while addressing to the query made by the government.
Category is PH vacancy position of contract teachers.
Yes.
For the advertisement June 2000, I mean we are talking of June
2013.
ସେଥିରେ ହେଲେ TGT category is PH vacancy position, selected field vacancy. Selected କଲା ପରେ vacancy କେମିତି ଦେଖିବେ ଆପଣ?
Sir, post a fill up ହେଇପାରିଲା. That post could not be filled up.
Why?
Because the number one candidate, my lord, as per the department's resolution.
ସେ ତାଙ୍କର ନଥିଲା.
हाँ sir, medical board ଯେତେବେଳେ when
ସେ ଗଲେ ତାପରେ ସେକେଣ୍ଡ ଲୋକ ଯାହାକୁ ସିଲେକ୍ଟ କଲେ ସେ ରଞ୍ଜନ କୁମାର ଦାସ ସେ ବି ଗଲେ.
ସେ ବି ଗଲେ.
तो ये नेक्स्ट लोक हेले ये याकू कहीं अपॉइंटमेंट न देगी क्लासिकल संस्कृत आनले
सी माने by the time माने for considering the candidature of the third person who was not available in that provisional list, by that time, my lord, there was a ban order.
So how could you appoint the classical teacher then? If there was a ban order, how could you appoint anybody in the first place?
That is the person who had already been selected. Lordship may come to that particular chart. It is at annexure C/2, page number 19 to our counter, madam.
C/3.
Sorry, madam. There is a provisional select list of the PS candidate, madam. Yes, madam. Stream TGT Arts.
Yes.
There the name of the petitioner, my lord, doesn't appear.
So that is what I am saying. In the merit list, his name was there. In merit list, his name was placed at serial number 5.
Serial number 5.
1 and 4 are PS candidates. 1 did not qualify for some reason.
Yes.
You disqualified him. The fourth candidate, Ranjan Kumar Das, also was disqualified. So he was the only candidate available. Only eligible candidate. Apparently, this is what appears. Then
And my lord, as against stream classical Sanskrit, another person's name has been already, he has been selected.
So, Sethu got a candidate in ethi bharti kori. This is what appears to have been done.
My lord, one thing more, man. If the lordship will come to that ban order, what the government is actually telling that it is a ban order, man. That is annexed F/2, running page 24, man.
F/2.
F/2.
F to nahi hai.
Number would have. The F/2 means in the F/2 in that particular focus. Counter which is previously filed, my lord.
ठीक.
I could not make it correct. Say that 11/12/2033. 13.
Yes.
That's what it meant. That is 11/12/2013, man. Relying upon this particular letter, my lord, we are saying that it is no more feasible.
But by such time that person had already been, that classical teacher had already been selected and appointed in his place.
I think my counter is silent on that one. But here in this case, my lord, if your lordship will come to the last line itself, there will be no engagement beyond 16/12/2013 in any circumstances. Further, the said unfilled vacancies provided by you will not be filled up later without prior permission of the director. So they could have also.
They could have done.
Yes.
But the thing is that in PGT arts,
Well, with respect to that,
no, thing is that against 168 vacancies,
yes,
only 3 PS candidates could have been selected. Apart from the fact that they can also be selected on merit, on their own merit.
yes, ma'am.
That is always available.
Yes, ma'am.
If they seek to be appointed against the PS quota, then first they have to qualify in the merit list, which he has done. He's placed at serial number 5.
This is serial number 5.
And among the PS candidates of that category, TGT category, he was the only person available.
Yes, that is why your lordship wanted to know that stream-wise, how the authorities could follow that particular stream-wise selection in respect of the special category people.
Yes.
And lordship may come to another document, my lord, that is 16/4/2016. Just I draw your lordship's kind attention to that reply with respect to 2013 vacancy and 2014 vacancy. That is 16/4/2016 is at page note 28.
28 of the?
Repeat, sir.
Yes. That is the ban order.
Sorry.
That is the ban order.
16/4/2016.
Yes. That is the ban order. No.
This is the letter from the government to the director. Subject is like this, my lord. I am directed to invite a reference to a letter dated 10/12/2015 on the subject cited above and to say that it is stated in the so-called affidavit filed by DEO Kendrapada before the State Commission for Persons with Disabilities of Odisha at point number 14 that whatever vacancy will be created in a particular PS category against the advertisement of June 2013 due to rejection of eligibility by appellate medical board will be carried forward and filled up from next advertisement. But it is mentioned in your aforesaid letter under reference that as per the report of DEO Kendrapada, one post of TGT as earmarked for SCBC PHOH is lying vacant out of vacancy advertised in the year 2013, which is contradictory. So that is why, my lord, hence you are requested to verify and clarify if the unfilled post of PH category relating to the advertisement 2013 has been carried forward to the subsequent advertisement, that is 2014. Further, you are requested to Further, you are requested to furnish a copy of the advertisement of engagement of the contract teacher 2014 and the number of persons recruited on each category against the vacancies relating to the advertisement of 2013 and subsequent advertisement to this department by 2014. Well, these are the questions, my lord. Reply to the same. In reply to the same, if a lordship will come to the next page, there they indicated, my lord, that with respect to the TGT arts, There are two vacancies meant for the PWD man. Total is 5. The categories under the TGTRs it is 2.
No, TGT arts ଆପଣ ଦେଖନ୍ତୁ vacancy Hindi ରେ ଗୋଟେ ଅଛି OH ରେ ଗୋଟେ ଅଛି.
Okay.
So we are talking of this OH.
Yes.
Madam, I have annexed the same only for the provision that is 33 of the Act, my lord. But carried forward if the selected candidate is not there, but the same category disabled candidate is not available, then you are carried forward to next advertisement. But in the first advertisement, that is the PS OS category, the PGTRs OS category, one post is vacant, reserved for TGTRs OS category. But the next advertisement, but that is not carried forward. That is 0, my lord. In 2014.
Yes, that is what I am saying.
That is therefore I am annexed the same.
My intention is also to show the same.
So ସେଇ ଜାଗାରେ ସେ କରିଦେଇଛନ୍ତି classical Sanskrit କୁ ନାଇଁ
If the lordship will permit me, then I can take that instruction only to limited so that otherwise your lordship.
I'll let you. I'm giving you one more chance. I'll call it next week.
Specific on this particular issue.
Not further arguments in part. In course of hearing, it is brought to the notice of the court that pursuant to a query posed by the Director of Secondary Education, the District Education Officer Kendrapada, by letter dated 25/8/2016, bracket Annexure 7, submitted and furnished the category-wise PH vacancy position of contract teachers for advertisement 2013. It is seen that there is one vacancy. There was one vacancy under the OH category of TGT Arts. The category-wise position for advertisement of the year of November 2014, however, does not show any vacancy under this category. This court would like to know as to how the vacancy was filled up without being carried forward to the next advertisement. Place this matter next week. Learned State Council shall address this court on the above point after obtaining necessary instructions. Yes.
Item number 8.
ଆମେ ଯୋଉଟା ଚ୍ୟାଲେଞ୍ଜ କରିଥିଲୁ
କମିଶନର ଅର୍ଡରଟା
ଅଟୋମେଟିକାଲି ମାର
ଆଇଟମ Yes, Mr. Lanka.
I'm filing the rejoinder today.
Yes. The Niranjan Lanka, learned counsel for the petitioner, files rejoinder in the court after serving copy on the other side. Have you served it on the state?
But I'm filed state matter. The whole difficulty, the government has not filed. I have challenged.
Oh, you are filing rejoinder to the counter filed by the private opposite party.
Private opposite.
All right, after serving copy on the other side.
Government has no counter filed.
The Anganwadi worker, the petitioner has been appointed by filing document.
I will do that. Rejoinder has been filed. Are you ready? We will take it up later or
we are ready, because all documents have filed. And ADM has also taken care of all those documents.
All right, we'll take it up.
My counter is necessary because I have challenged the order of the lordship of a glance. The order challenge before your.
Yeah, what is the matter? Let us see. Why is the improved order to sold passed by the Leonard ADM revenue misappeal? Revenue misappeal?
Anganwadi appeal को separate nomenclature है revenue misappeal. Annexure 5 is the impeachment order.
Okay. But it is Anganwadi appeal to? Whatever may be the nomenclature.
Page 16 of lordship.
No, please, Mr. Lanka, please place the facts.
The facts
sequence.
the portion to the advertisement I applied.
Yes.
I was selected,
Given appointment.
appointed.
All right.
While I was continuing, the opposite part number 5 filed the revenue misappeal number 15 of 2015 on the ground that I have submitted the false document. And the document, that is the matriculation certificate, where I have obtained 87.5 marks, that has been issued by the CBSE. CBSE was not a party in that proceeding. What the ADM held, he held that the document has been false. But how it, and he has stated that the documents obtained by the opposite part number 5, that is appellant in the appeal, from RTA Act appear that it is a false document. That is the ground my selection was cancelled. That challenging that I have to.
Let us see that relevant portion of the impugned order.
On page 26, Lordship.
Of the impugned order.
Yes, my lord. Page 26.
I think 23
to 26, madam.
You can start from page 25, the last paragraph.
Yes, sir.
Anyway, it's nothing.
From 24 last paragraph, your lordship may kindly see.
This is your submission.
Yes.
This is just, he has recorded your submission. So we can come to the
page 26, the last paragraph.
Please, sir.
Admittedly, there is a respondent number 2, Hiravati Sahu, has been secured highest mark than the other applicants.
Who are you? What is your name?
Hiravati.
You are Hiravati.
Yes.
Your name?
No, my name is Pushpanjali Muduli.
So you had filed the appeal?
Appeal.
Yes.
Yes.
So you are Hiravati.
My appeal has been allowed.
Yes.
Yeah, I get the point. Now, so admittedly respondent number 2, Hiravati. No.
Last 5 lines. Whether the ADM is correct in relying on the said rules of CBSE, particularly when the petitioner has passed the matriculation certificate examination under the BSE Orissa to his CBSE rules, is not applicable. Therefore, my lord, it is the assertion and admission of the petitioner that she has passed the matriculation examination from Board of Secondary Education Orissa. Your lordship may kindly see. There are so, your lordship may kindly come to the running page 39 or page 13 of my counter, annexure F by 5 series, where through RTI, I have obtained the application form of the petitioner, where CH categorically stated that CH passed from CBSE Delhi by securing 87.4% mark in CBSE examination. It is directly contradictory. And your lordship may kindly see, thereafter, my lord, CH filed an affidavit. The affidavit is, my lord, as page 44 of the running page or page 18 of my counter affidavit, where she has stated that her date of birth is 5/6/1994. But the real fact is that, my lord, again I will take your lordship to the pages. My lord, where she has held in HSC examination conducted by Board of Secondary Education Odisha, and her date of birth is 1990. Your lordship may kindly come from page running page 34, annexure A by 5. There is the school leaving certificate, where the date of birth of the petitioner has been mentioned as 5/6/90. Next page, my lord, the admission register, where the date of birth again is mentioned at 5/6/90, 1, 2, 3, 4, 5, 6, 7th column, my lord. Thereafter, my lord, the attendance register, that is formal, my lord. Thereafter, lordship may kindly see the tabulation register given by Board of Secondary Education obtained through RTI. My lord, 1, 2, 3, 4, 5, 6, 7 clause, my lord. Hiravati Sahu, father's name, Urvasi Sahu, mother's name, Jita Sahu, father's name, date of birth 5/6/90, and fail. Result is fail, my lord. But she has stated wrong father's name, mother's name in the CBSE examination, so called, and stated that I passed in HSC examination. But in HSC examination from Mahaberna High School, my lord, she appeared through it and failed in the examination. Date of birth is 5/6/90, but she has filed a false affidavit stating that my date of birth is in the year 94. And in the application form itself, my lord, she has stated that I have passed matriculation from CBSE Delhi 87.5%. I also, my lord, obtained the relevant information from CBSE that whether and
I've seen it, I've seen it.
well, you can
But I'll tell you,
examination.
you see, this court is not going to make a roving inquiry.
Malad,
This is in statutory jurisdiction.
Malad,
Scope is very limited.
Malad,
The order passed by the quasi judicial authority has to be tested
Malad,
on the principles of natural justice,
Malad, Malad,
whether there's any perverse finding or not.
Malad.
Here, prima facie, what I find is that he has not given any finding at all. He has simply noted the submissions made by the both side lawyers and then come to a finding.
Documents.
And abruptly he has come to a finding. He has to justify it. He has to give a reason.
Malad.
I'll have to remit it.
Malad, you lordship,
I'll remit it. Listen like that. I'll not whisper a word on merit. I'll simply remit it. How did you come to a finding that it is a fraud? Whatever both sides will be given.
Two decisions only I rely on, if your lordship.
Kौन?
If first appointment is possible.
Certificate.
Mr. Hon'Ble, I am not going to pass any order on merit.
Malad, Malad,
I will simply remand it, asking him to conduct a fresh inquiry and to give reasons.
Malad, Malad.
The petitioner has approached this court seeking the following relief. The brief facts of the case are that pursuant to an advertisement issued by the CDPO Agalpur, Duduka, in the district of Balangir, for engagement of Anganwadi worker, Ku thana jagata seta? Amaramunda Anganwadi Center on 18/6/2015, the petitioner submitted her application. The selection committee found her suitable for engagement. Accordingly, she was appointed or engaged rather, was engaged. Sorry, 18/6/2015 भूल गई. Advertisement data कितना कहले?
Advertisement date.
(22) 2015.
22 तो?
20.
22 2015. तब लिख ला अपॉइंटमेंट का जो एंगेजमेंट अकाउंट लिख ले. एंगेजमेंट का अकाउंट लिख ले. Found her कौन? Suitable. Suitable for engagement. Accordingly, she was favored with an order of engagement by the CDPO on 18/6/2015, pursuant to which she joined. Her selection and engagement was challenged by the present opposite party number 5 by way of an appeal filed before the Additional District Magistrate Balangir, which was registered as Revenue Miss Appeal number 15 of 2015. अंगनवाड़ी अपील तो आपने लिख लिया. से इलेक्शन की तो इनपुट ऑर्डर है, देखो ना थी. Revenue Miss Appeal number 15 of 2015. The main ground of challenge to the selection and engagement of the petitioner was that she had submitted a forged matriculation certificate showing her to have been issued by the CBSE Delhi, Central Board for Secondary Education, CBSE Delhi. The ADM accepted the contention raised by the appellant and accordingly held that the documents submitted by the certificates that the petitioner had been selected on the basis of a forged certificate. Stop the appeal was thus allowed, and the sub-collector Balangir and CDPO were directed to take steps for engagement of Anganwadi worker of the center. In course of hearing, Sri Niranjan Lenka, learned counsel for the petitioner, submits that the order of the impugned order is not reasoned, is an unreasoned one, in as much as the ADM has not specifically cited any reason as to why he held the certificate submitted by the petitioner to be forged. Stop. Sri Tilochan Nanda, learned counsel appearing for the opposite party number 5, submits that from the documents obtained by his client under the RTI Act, it is clearly revealed that the petitioner had played fraud, and therefore her selection was rightly cancelled. After perusing the impugned order, this court finds that the ADM has referred to the facts of the case therein, and thereafter recorded the rival contentions, and thereafter suddenly arrived at the conclusion that the petitioner had been selected by showing the forged certificate. No reason whatsoever has been ascribed to justify such finding. It is well settled that an order sans reason cannot be countenanced in law. Stop. Reason is the soul of an order, without which the same becomes susceptible to challenge. A quasi-judicial it is incumbent upon a quasi-judicial authority like the ADM to examine the facts of the case and the evidence laid before him, and to arrive at his own finding. The order may be the result of his subjective satisfaction, but in any case, he has to support his findings by giving adequate reasons. After perusing the impugned order, this court finds that the same does not contain any reason to justify the finding arrived at by the appellate authority. As such, the impugned order cannot be sustained in the eye of law. For the foregoing reasons, therefore, the writ petition is allowed. The impugned order passed by the ADM in Revenue Miss Appeal number 15 of 2015 is hereby set aside. Stop. The matter is remitted to the ADM to hear the appeal afresh after giving opportunity of hearing to all necessary parties and to pass a reasonable order in accordance with law. Stop. Since the original appeal is of the year 2015, the ADM shall do well to dispose of the appeal within 2 months. Within 2 months from the date of production of certified copy of this order by the petitioner.
By any of the parties, your lordship.
by any of the parties.
Yes. Grateful, my lord. No, my lord, I may be given liberty to file all the documents again before it. Recorder thibo no thibo.
It shall be open to both parties to support their respective, to substantiate their respective stands by filing uh, um,
Relevant.
documentary evidence, by filing relevant documentary evidence. Yes.
Great.
By submitting. Yes.
Great.
Item 9. Yes, anybody?
My lord, may I kindly pass over this item?
Pass over. How pass over? Pass over. All right, go. Pass over, call Mr. Vishwal quickly. Yes.
Item number 10.
Item 10, my lord, I seek for a week's time to file the affidavit which your lordship had directed. The physically handicapped category.
ମୁଁ ଆଜି ଆପଣଙ୍କୁ affidavit ଫାଇଲ କରିବାକୁ ତ ଖାଲି ଅର୍ଡର କରିଥିଲି କିନ୍ତୁ ମୁଁ ଆପଣଙ୍କୁ କଣ କହିଥିଲି?
Lordship had directed to.
କଣ ମନେ ନାହିଁ? କଣ କହିଥିଲି? I had asked you to use your good offices to see that justice is done in respect of a physically handicapped person.
Yes, your lordship had said so, but they
counter affidavit
want to file an affidavit as to how he cannot be adjusted under the situations.
No, he was the second physically handicapped candidate.
Yes.
The others were not available. So we should have been given the appointment.
That should have been, but now the present situation, they seek to bring to your lordship's notice by way of affidavit.
No, the question is, he is a physically handicapped person. He has been running to the court for years together.
Yes.
How long will the court?
That should not have happened, but because of the fact that some factual aspects are to be brought to your lordship's notice, I seek a week's time so that I will file that affidavit. Thereafter, your lordship may pass appropriate order.
He says his case specifically is that the candidate who was appointed, the first candidate,
Did not
he never joined. So the post was lying vacant. He could have been, he being the second candidate, he could have been adjusted.
How that is still not possible that they seek to bring to your lordship.
Why is it not possible?
That they will be filing by way of affidavit. They have not told me so in so many words, but they seek some time to get those materials to your lordship.
Yes, what do you say, Mr. Koro?
Sir, ମୁଁ ଟିକେ କହିବି।
ଆଉ କିଛି କହିବା ଦରକାର ନାହିଁ। ଆପଣ କେତେ ମୁଁ ବିଷୟରେ ମୁଁ ତ କହୁଛି ଆପଣ କଣ କହିବେ? ଆଉ ଅଧିକା କହିବେ ମୋଠୁ।
ନୂଆ ଆନେକ୍ସ ଗୋଟେ କହିବି।
କିଛି ନୂଆ ଏଇ ଆପଣଙ୍କର ଅସୁବିଧାଟା ଆଜ୍ଞା ସେଇଠି ହଉଛି। ଆପଣ ନିଜେ ବୁଝିପାରୁନାହାନ୍ତି। ଆପଣ ଜଣେ ଓକିଲଙ୍କୁ ଦେଇଥାନ୍ତେ ଯଦି କିଏ ସେ ତ ଅଲଗା କଥା, କିନ୍ତୁ ଆପଣ ନିଜେ ଯେହେତୁ କରୁଛନ୍ତି ଆପଣଙ୍କର ଭାବାବେଗଟା ରହିଯାଉଛି। ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି ଆଜ୍ଞା। ପଚାରନ୍ତୁ ଏଠି ଅନ୍ୟମାନେ ଯେତେ ଜଣ ଓକିଲ ଅଛନ୍ତି କୋର୍ଟ କଣ କହୁଛନ୍ତି ଆପଣ ବୁଝିବାକୁ ଟିକେ ଚେଷ୍ଟା କରନ୍ତୁ। Court very well understands your pain. You have been running to this court, and this court would definitely like to dispense justice if there has been injustice to you. Don't worry about that. You will get justice if there has been an injustice. यदि law अनुसार जहाँ होगा तो ठीक है किसी को नहीं बुझिपारे तेणु आप व्यस्त हूँ कि आउ एत डॉक्यूमेंट ये सब जिन बंद कर ଆପଣ ଦ୍ୱିତୀୟ କ୍ୟାଣ୍ଡିଡେଟ୍ ଥିଲେ ପ୍ରଥମ କ୍ୟାଣ୍ଡିଡେଟ୍ ଜଏନ୍ କଲେ ନାହିଁ ସୋ ଯେହେତୁ ଜଏନ୍ କଲେନି ଭ୍ୟାକେନ୍ସି ହେଲା ଆପଣଙ୍କୁ ଦିଆଯାଇ ପାରିଥାନ୍ତା ଆପଣଙ୍କୁ କାହିଁକି ଦିଆଗଲା ସେଇ କଥା ତ ପଚରା ଯାଉଛି ଗୋଟେ କଥା ତ ଏତେ କଥାରୁ କଣ ମିଳିବ ଆନେକ୍ସ ଦେଖି କଣ ମିଳିବ
ସାର୍ କିନ୍ତୁ ଗୋଟେ ମିନିଟ୍
କଣ ସେ କଣ କହୁଛନ୍ତି କଣ
ସାର୍ କିଛି ଲୋକ କିଛି କ୍ୟାଣ୍ଡିଡେଟକୁ 2006 ମେରିଟ୍ ଲିଷ୍ଟରୁ 2009ରେ ବି ଦିଆଯାଇଛି
ଆପଣ ସେ କଥା କହୁଥିଲେ ସେ that is what you were saying
ଆଉ ସାର୍ ମୋ କହିଲା
that I know that you have said that Sri Das Lana Deji requests for a week's time to apprise the court on the query posed on the last occasion. Considering the fact that the petitioner is conducting his case in person, this court is ordinarily not inclined to grant further time. However, for the ends of justice, the matter is adjourned for the last time to next week. the previous order will be complied with positively. Our week, final habo. It is made clear that no further adjournment shall be granted under any circumstances. Yeah.
Item number 11.
May please. My lord, the impugn order under Annexure 7. There, my lord, the direction has been given to initiate dependence against me, my lord.
The counter has been filed.
Yes, my lord.
Counter has been filed.
Yes, my lord, counter filed.
You are challenging annexure?
Annexure 7, my lord.
Annexure
Yes, my
7.
lord. Start from page 24.
इसी केस में कौन जोगाना सहायक हो?
Johan sir.
You have been disengaged.
Yes, my lord.
Oh, that detention of PDS rights, yes. कौन से भूल कौन? The factual finding कौन भूल?
Factual finding only my respectful submission is that, my lord, on the same ground, my lord, same case, an FIR has been lost. In that criminal proceeding, I have been acquitted. And interesting part is that, my lord, the person from whom the PDS rights was seized, he has not been arrested and accused. He has not faced charge sheeted. He has not faced the trial. And finally, I have got my lord.
You have been acquitted.
Yes, my lord.
You have given that order.
Yes, my lord. I have that.
But that is after passing of this order.
Yes, my lord.
Oh, let him consider this.
Your lordship.
Let him consider this.
Yes, ma'am. If
Will you-
lordship directs, that may be again considered.
Yes, because
But in their counter affidavit, they have said about what prevented the authority to give him engagement.
what, where is it? Where is it? Tell me.
At page
Let us
10
see. Which?
of the counter affidavit,
ये category page?
page 10.
Internal page.
Yes.
Yes.
That guidelines. No,
है ना?
No, that.
ଓଡ଼ିଆରେ କଣ ଲେଖା ହେଇଛି? ତେଣୁ ଏଭଳି କାର୍ଯ୍ୟ କଳାପ କରୁଥିବା ୱାର୍ଡ ସଭ୍ୟ ମାନଙ୍କ ଉପରେ ବଦନାମ
ସହାୟକଙ୍କୁ
ତେଣୁ ଏପରି ଏକ ଅମାନିଆ ଦୁର୍ନୀତିଗ୍ରସ୍ତ ଯୋଗାଣ ସହାୟକଙ୍କୁ ଆମ୍ଭ ଗ୍ରାମ ପଞ୍ଚାୟତରେ ଯୋଗାଣ ସହାୟକ ପଦରେ ରଖିବାକୁ କାର୍ଯ୍ୟ କରିବା ପାଇଁ ଚାହୁଁନାହାନ୍ତି।
କାର୍ଯ୍ୟ କରିବା ପାଇଁ ଚାହୁଁନାହାନ୍ତି। This is by the villagers.
ସେଇଥିରେ କଣ ହବ?
ସେଇଟା ସରପଞ୍ଚ, not by the village, that is ସରପଞ୍ଚ.
Mr. Das,
Sir,
fact remains that he has been acquitted of the charges.
that is a fact. But at the same time, as your lordship knows, in view of the full bench judgment, that in itself.
No, it can have a bearing. Because I think there's a judgment of full bench, I don't know, but
Full bench judgment is.
the Justice Muralidhar's judgment, as his lordship then was, he was referring to a Supreme Court judgment. He says that since the standard of proof in a criminal case is much higher than that of departmental inquiry,
Reasonable doubt.
that is beyond reasonable doubt, this is preponderance of probability. So that will have a bearing. Not that automatic exoneration, I'm not saying that. So let him consider. Let him, yes, Mr. Das.
Right.
Let him consider the effect
My
of.
submission is that, my lord, what my lord is senior is submitting regarding that resolution, my lord. The person from whom the PDS rights was seized, my lord, he has not been arrested as an accused.
I'll say that. Let him consider the effect of these two things.
But basing upon his statement, I have been.
All right. Sri Devoprata Das, learned counsel for the petitioner, and Sri A.R. Das, learned additional government advocate. All Das. Separate with us, separate with us. And DSH. I mean, I'm just looking at the. No, just the spelling. Nothing more. I'm not implying anything. It is submitted that the petitioner has approached this court seeking the following relief. The case of the petitioner is that he was appointed as Jogan Sahayaka under Kuchaga Gram Panchayat in the district of Kolahandi. By order dated 9/12/2010 of the Sarpanch of the GP. He was on an allegation of misappropriation of 1 quintal of PDS rice, he was called upon to show cause. Besides, an FIR was also lodged in Joypatna police station, leading to registration of Joypatna PS case number 46 of 2021 for the alleged commission of the offence under section 408 IPC. In the meantime, in the departmental proceeding to in the meantime,
has been
nice.
EC proceeding.
No, sir, in the meantime, on consideration of the show cause reply submitted by the petitioner, final report was submitted by the investigating officer holding the petitioner guilty of the charge. Accordingly, EC case number 4 of 2020 was initiated by the collector. By order dated, by order dated, order date लिखना थी. By order dated 29/12/2023, the EC case was disposed of, directing the BDO Joypatna and Sarpanch of the GP to initiate disciplinary action against the petitioner. It was interimly held that the allegation as leveled against the petitioner stood proved. Stuff. Subsequently, the criminal case, being city case number 45 of 2021, instituted against the petitioner on the basis of the FIR lodged by him, ended in acquittal. As per judgment passed by learned JMFC Joypatna on 19/1/2024. In the said judgment, the learned JMFC held that
At page 47.
held that the prosecution had failed to prove the offence under section 409 of IPC against the accused beyond all reasonable doubt. Stop. Shri Debabrata Das, learned counsel appearing for the petitioner, submits that firstly, the person from whose possession the PDS rice in question was seized was never arraigned as an accused. And secondly, the innocence of the petitioner is proved by the judgment of acquittal passed in the criminal case. He further submits that Sri A.R. Das, learned AGA, submits that acquittal in the criminal case cannot lead to automatic exoneration in the departmental action or proceeding. Having heard the rival submissions, and upon going through the materials placed on record, this court feels that the petitioner that the contentions advanced by the petitioner, as mentioned above, carries considerable force. It is well settled that the state cannot discriminate between persons standing on the same footing in the matter of disciplinary action. In the instant case, it has been alleged that the person from whose possession the PDS rice was seized was never arraigned as an accused.
His name is my lord. I have also organized the
He is an outsider.
one my lord that ration card holder who
He is a beneficiary. He is an outsider. So no, he cannot be departmentally proceeded, but only criminally he could have been
this
proceeded.
guy can be initiated, my lord.
Wonderful. In the criminal case. Criminal case instituted on the basis of the FIR lodged by the BDO Jayapatna. Stop. Secondly, the criminal case has ended in acquittal as the prosecution could not prove the charges. It goes without saying that the standard of proof required in a criminal case is much higher than that required in to prove misconduct in a disciplinary proceeding. Stop. Be that as it may, since the judgment of acquittal was passed subsequent to the passing of the impugned order by the collector, this court is of the view that ends of justice would be best served if such fact is also taken into consideration by the collector to decide the matter finally. In such view of the matter, the writ application is allowed, the impugned order is set aside, the matter is remitted to the collector Hon'Ble to decide it afresh after taking into account the judgment of acquittal passed in the criminal case. That's all.
So also other judgments of this honorable court, so also appeals.
That you need not add. It shall be open to the petitioner to produce all necessary, all relevant documents in support of his case at the time of hearing. So, the collector shall act upon a certified copy of this order to be produced by the petitioner and dispose of the matter after granting him an opportunity of personal hearing. Stop. The case shall be finally disposed of within 2 months from the date of production of the certified copy.
Okay.
Yes.
Item number 12. 9.
Pass over to wait for.
Item 12, last token notice was pleased to issue notice. The other side has appeared. For OP number 4. Because his selection and appointment under what challenge.
Was sufficient.
Yeah. Some advocate last occasion appeared, some Das from Bhubaneswar.
Mr. Sambit Das. The advocate's name is Mr. Sambit Das. Is not there?
No, today he is not there.
Sri Joshi, learned counsel for the petitioner, is present. Not case for the opposite party number 4 on repeated calls. Place this matter next week. On 16 July.
Item 13.
Yeah, ପରେ 13 ପରେ ଦେଖିଦେବ 9 ଟା.
Next, your lords. In this case, my lord, petitioner has challenged the order of a disengagement, my lord, made under annexure 1. Counter page, reason to file, my lord.
I have already solved a copy and I am solving a hard copy of it.
Learned AGA files the hard copy of the counter he filed earlier.
Yes.
Same be kept on record. Sri Satpathy, learned counsel of the petitioner on whom a copy of the counter affidavit has been served, seeks time to file a rejoinder. List this matter on 23rd July. Rejoinder, if any, be filed in the meantime. Like the password.
So item number 9.
In item 9, your lordship, on the last occasion, on 9.
Required to produce a copy of the guidelines.
So any date, my lord, it may be so that we can produce them.
Tomorrow?
Yes.
Tomorrow?
Yes.
Day after tomorrow then? Then State Council submits that he is ready with the guidelines and would like to file a copy thereof. List this matter day after tomorrow.
Entry model.
Entry model to continue.
Okay. Item number 14.
Item 14. The password कर देता.
Item number 16.
One six.
Yes.
This is a transfer application. Petitioner before lordship with wife. Yesterday this matter was there.
Yes.
Nobody appears on behalf of the public party. For which my lord. It has come. The divorce proceedings pending before the learned judge family court, Noyagarh.
So let us pass it over for some time. Then after the list is over, if it is, nobody appears, then we'll give one more opportunity. तापर dispose of करवा आर week रे को पे. 3 people नहीं था बेटा खाली password करता तापर देखिए.
Item 17.
My pleasure, lords. But
Opposite party husband.
Item 17.
Mallet.
Yes.
Well, here the transfer application is by the wife to transfer the matrimonial proceeding from Baleshwar to Uddala, my lord. But at Uddala there are 2 other proceedings pending. At the instance of the wife.
Now working as a additional people.
Additional?
APP.
Oh.
I am working as a Koraput.
Koraput.
Only particular.
So how does it matter whether you come to Baleshwar or to Uddala? I grant you liberty to appear through virtual mode.
Now stay vacanted. Now I am expert. Board already declared expert. Evidence closed.
Evidence closed.
Evidence closed on their behalf, on behalf of the petitioner.
नहीं ଯଦି ପାଠ ହେଇଗଲାଣି ଆଉ
no
ପାଠ ହେଇଗଲାଣି ଆଉ
ପାଠ ମାନେ ଏଇଟା ଷ୍ଟେ ଅଛି the proceeded ଗୋଟେ ସେ କେବଳ evidence ଦେଇକି they close the evidence on their side.
up to them.
Application has been filed to recall that witness again.
That will be
at this stage, and he is also participating at Uddala in the other 2 proceedings, DB proceeding and the GR case.
No.
And the petitioner,
no.
And only minor son is there with the petitioner, no other person is there with him.
Uddala Baleshwar hardly 40 भी होगा आउरी कम 30 किलोमीटर भीतर हो
नहीं more than 45 to 50 भीतर
ये भीतर बात होची दुर्गा देवी की बात होची गले 25 किलोमीटर पहुंच
केवल माइनर
दुर्गा देवी बड़ साई दी की
आउ के मु तो जानि
मु जानि छी मु एबी जे थिली सेठी बालेश्वर रे तो मु जानि छी माय फर्स्ट पोस्टिंग वाज एट बालेश्वर आई नो
the only minor son she is residing with her only minor son, no other person is there also.
matter hearing आरंभ है आउट ट्रांसफर हो हियरिंग आरंभ है गोटे कोन असुविधा हैता
very well सी केवल गोटे डेट रो एविडेंस देई से क्लोज कर देइ छै तापर हमें रिकॉल फाइल करछु
सॉरी मिस्टर पनगरे
स्टे ऑर्डर is also there.
So you need to say that violating the stay order done it Asian resurfacing से तो लगी करथि कोन in course of hearing it is
well सेटा हमें रिकॉल फाइल करछु लॉर्डशिप
no it is stated at the bar that hearing of the case in the court below has already begun with evidence from the side of the petitioner being closed.
By my husband, respondent.
In such view of the matter, this court does not deem it proper to direct transfer of the proceeding to any other court. It shall be open to the petitioner of this case to seek recall of the witnesses so examined, as also to appear through virtual mode if she so desires, by seeking permission of the court. The transfer application therefore stands dismissed or disposed of with the above observations. Obliged. Yes.
I'm sorry, beloved. Item 14.
Next one.
No instruction.
Item kete bole?
14. 1 4.
Item 14, no instructions, disposed of.
Item number 18.
Item 18.
Yes.
I think that order has been recalled.
Yes, ma'am. My lord, sir, the order has been recalled and my lord wanted to have a re-hearing the matter.
No, we have not recalled it so far.
Last occasion.
नहीं उसे औरता खाली ये अर्जुन हुई ला इक्वल टू कुल चला नहीं ये आइटा कर लो बा इटा कर नहीं से रॉन्गली किंतु करा है नहीं वो भूल ले से नहीं रिपीटेशन रह जाई छी आइए ले कर दियंतु आइए 777 777 of 2024 तो
Sir, 1 minute.
से थे लोगों
5897 that IA.
This is an application for modification of the judgment passed on order dated 17/5/2024. It is submitted that the matter is not entirely covered by the ratio laid down in Dr. Ashok Kumar Mahathi and others?
Yes.
Versus State of Odisha, which has been inadvertently mentioned. In such view of the matter, order dated 17/5/2024 is recalled and the writ petition be placed for hearing. Yes. Will you hear it today?
Yes. I should be sir.
Yeah, I am.
I will place my date chat because I have written entire detail. I have given my.
No, we will hear it. Of course, we will.
Dates of hearing.
Before that, can you please place the prayer? What is exactly the prayer?
Exactly.
Confusion confusion
Let's say that
One of the portion of the prayer is also
there, but the entire you also have a look to the prayer I have made in that writ application.
Yes.
consolidated at 27. Consolidated.
Yes, consolidated.
27.
To allow you the increments from 2002, 3 and 4.
My lord, that page 27.
Yes.
Under the above appropriate by directing the opposite parties to allow the increments to the petitioner for the year 2002, 2003 and 2004 without any further delays. Further, the Honorable Court be pleased to direct the opposite parties 1 and 2 to grant senior lecturer scale of pay in favor of the petitioner with effect from 1/6/1993 on completion of 7 years of teaching experience and to grant 2 additional increments to the petitioner in lieu of his acquiring MPhil qualification, to grant the petitioner the selection grade lecturer scale of pay with effect from 1/6/2001 and to fix the pay of the petitioner in the senior lecturer scale of pay with effect from 1/6/93 in the scale of pay rupees 3,000 to 5,000 and to fix up the pay of the petitioner as per college teachers rules 2001 with effect from 1/1/96 in the senior lecturer scale of pay, that is 10,000 to 15,200 instead of the fixation made in favor of the petitioner on 1/6/96 in the scale of 8,000 to 13,500. Further, the Honorable Court be pleased to direct the opposite parties 1 and 2
to fix the pay of the petitioner in the scale of pay of the selection grade lecturers with effect from 1/6/2001 in the scale of 12,000 to 18,300 and to refix the same by taking into increments as are available to such time scale of pay and to calculate the differential dues of the petitioner considering such refixation and to release the same within the time stipulated time as deemed fit and proper, etc., etc.
Yes.
Here, my lords, at this juncture, my lords, can have a look to my chronological dates of events and need to data file.
Yes.
The lords can kindly come to page 2.
Yes.
19/4/1908. The petitioner having the requisite qualification, that is 56% of marks, in postgraduate qualification in English, was appointed as a lecturer in English following due process of selection by the governing body of Chaudhar College, Chaudhar, and the petitioner joined the post on 19/4/1985. The petitioner acquired his MPhil qualification in the year 1990 and was placed in the first division in the said examination. 1686, Chaudhar College was taken as an aided college by the government. 1995, though the petitioner was appointed in due process of selection and was against the sanctioned post, since the petitioner's appointment was not approved and the salary component was not released, the petitioner filed a writ application before this honorable court during OJC number 1561 of 1993. 2012-1994, the writ application filed by the petitioner was allowed by the honorable court with a direction to approve the appointment of the petitioner and to release the salary component of the petitioner within a period of 3 months from the date of receipt of the order. 26/1995, the state government accorded approval of the appointment of the petitioner against the post of lecturer in English, taking the date of admissibility of the post on 10/8/1985, and accordingly released 1/3 salary component in favor of the petitioner with effect from 1/6/1991. 1995, the petitioner approached this honorable court in OJC number 5189 of 95, challenging the order of approval made by the state government dated 26/9/95, since the petitioner was approved against the 4th post of lecturer and the said writ application was disposed of by order dated 22/8/1995 with a direction to the petitioner to make a representation to the opposite party number 2 for necessary decision relating to the approval of the appointment against the 3rd post of lecturer, and accordingly the petitioner made a representation to the authorities for consideration. 22/1/2000, the state government accordingly reconsidered the matter and accorded approval of the petitioner against the 3rd post of lecturer in English by the order dated 22/1/2000. Though the petitioner had joined the post as lecturer in the Chaudhar College on 19/4/1985, but in the order dated 22/1/2000, the date of joining of the petitioner was erroneously indicated as 10/8. That should be 85. 95, that will correct it 85. Be that as it may, the order indicated that the post was filled up by the predecessor of the petitioner on 12/9/1980, and the admissibility of the post for granting aid was indicated as 1980-81 and sanctioned against granting aid against the said post at the rate of 1/3 with effect from 1/6/1986. Till that, there is no problem. That has been accepted. On 25/10/1996, the petitioner was transferred to UN College Soro in the district of Balasore. 22/4/2000, the pay of the petitioner was fixed with the approval of the accounts officer of the Directorate of Higher Education in the scale of 2200 to 400. Your Lordship may pause it, that is the UGC scale of pay. With effect from 1/6/1986, allowing the next increment on 1/6/1987 in the said time scale of pay. The pay has been revised by the authorities. Earlier, the petitioner was put to the scale of pay of 1350 to 2975. Hence, the scale of pay of rupees 2,200 to 4,000 was made available to the petitioner with effect from 1/6/1986. The above salary was released with effect from 1/6/1986 as because the college was declared an aided college with effect from the said date, 1/6/86. Accordingly, by order dated 31/3/2000, the differential salary of the petitioner was released and the same was communicated in letter dated 31/3/2000 of the accounts officer of the Directorate of Higher Education. The annual increment of the petitioner accordingly was sanctioned from 1/6/87 to 1/6/899 in the scale of pay of 2,200 to 4,000 as is entitled in this, as is entered in the service book of the petitioner and was released in favor of the petitioner. As on 1/6/1999, the pay of the petitioner was fixed at rupees 3,300 in the said time scale of pay of rupees 2,200 to 4,000. 39/2001, the state government adopted a new pay revision rule known as ORSP Rule 1998, given effect from 1/1/1996 and made applicable to the employees of the state. As per the said rule, the scale of pay of rupees 2,200 to 4,000 was revised to 8,000 to 13,500 in the said rule. Accordingly, the pay of the petitioner has been fixed in the scale of pay of 8,000 to 13,500 as on 1/1/96 at the rupees 8,550, and the petitioner was granted increments as was provided in such time scale of pay till 1/6/2000 at rupees 9,925. Therefore, the petitioner is entitled to the differential scale of pay as has been fixed by Annexure 6 vis-a-vis Annexure 5, but the same was not released by the authorities, although from the month of April 2002, the petitioner received salary at the rate of 9,925. The differential dues of the petitioner from 1/1/1996 to 1/6/2000 and the incremental dues of the petitioner from 1/6/2001 onwards has not been released in favor of the petitioner. The salary of the petitioner for the month of December 2001, January, February, and March 2002 has also not been released, although the salary of the petitioner from the month of April 2002 has been released in his favor.
Sir, just a moment. Is this area or this part from December to 2001 to March 2002?
Sir,
has it been released in the meantime?
No, ma'am.
It is still pending.
Still pending.
Not.
Then that was the first, the second. Then my lord, on 23/11/2001, the petitioner was transferred from UN College Soro to Tarini Hakrani Mahavidyalaya Ghatagaon, and the increment of the petitioner in the time scale of pay from 1/6/2001 onwards, since has not been sanctioned by the opposite party number 3, although the petitioner was continuing and discharging his duty. Therefore, the said due is to be released in favor of the petitioner, though the salary of the petitioner with effect from April 2002 was being paid to him, but the same was without taking into the incremental due of the petitioner as the petitioner was entitled to. 1999, the state government adopted the revision of pay scale as is prescribed by the UGC, and accordingly the notification was issued on 31/12/1999 to implement the same with effect from 1/1/1996, relying on the earlier resolution passed by the state government on 6th October 1989. In the counter also, the state government relied on the resolution dated 19/3/1990, which was made on the basis of the resolution dated 1/10/1989. According to the said guideline, the scale of pay of lecturer was scale of a lecturer which was 2,200 to 4,000 was revised to 8,000 to 13,500 scale of pay. A senior lecturer which was 3,000 to 5,000 was revised to 10,000 to 15,200. That means that was as per the new UGC scale, which was I was receiving 8,000 something, that was revised to 10,000 to 15,000, 2,000 with effect from 1/1/1996. And the scale of a selection grade lecturer's reader was 3,700 to 5,700 was revised to 12,000 to 18,300. This scale pay was extended to college teachers with effect from 1/1/1996. According to the guideline, said guideline, the lecturer having 8 years of service, here that Dr. Ashok Mahanti principle will have some application here. 8 years of service without having MPhil and PhD qualification is entitled to draw scale of pay prescribed for the post of senior lecturer, and the lecturers having 16 years of service without having MPhil and PhD qualification entitled to draw the selection grade lecture scale of pay. The lecturers having MPhil qualification entitled to get relaxation of 1 year for computation of service for the purpose of grant of senior lecture scale of pay and as well as selection grade lecture scale of pay. Therefore, petitioner being MPhil degree holder is entitled the benefit of senior lecture scale of pay on 7 years of service and selection grade lecture scale of pay on 15 years of service. The petitioner's appointment was approved with effect from 1/6/1986. The petitioner is having MPhil qualification. Therefore, the petitioner is entitled to get the senior lecture scale of pay in the year 1993, whereas when he completed 7 years of service, the petitioner is also entitled to selection grade lecture scale of pay with effect from 1/1/2001 on completion of 15 years of service. That in the year 1993, the scale of pay prescribed for the post of senior lecturer was 3,000 to 5,000. Therefore, the pay of the petitioner is to fix on 1/6/1993 in the scale of pay of 3,000 to 5,000 as is prescribed for the post of lecturer, post of senior lecturer scale of pay, and accordingly, the scale of pay is to be put in the scale of pay 10,000 to 15,200, which was the revised scale of pay of senior lecturers with effect from 1/1/1996. The same has not been extended to the petitioner. The pay of the petitioner has been fixed as 1/1/93 at rupees 2,725 in the scale of pay 2,200 to 4,000. Therefore, the same is to be refixed accordingly. The petitioner's pay has been fixed in the scale of 8,000 to 13,500 on 1/1/96, when the next increment is 1/6/1996. Senior lecturer scale of pay was revised to rupees 10,000 to 15,200 with effect from 1/1/96. Therefore, the pay of the petitioner is to be revised in the scale of 10,000 to 15,000 on 1/1/96, and in place of 8,000 to 13,500, which was fixed in favor of the petitioner in the revised lecturer scale of pay. 2001, the state government prescribed the pay revision rule in the name of Orissa revised scale pay for college teachers rule 2001. In the said rule, it was provided that 2 advance increments will be paid to lecturers with effect from 1/1/96 having MPhil/MLit qualification. Therefore, though the petitioner is entitled to 2 advance increments, the same having not been extended to the petitioner prayed for release of the same. As the petitioner is entitled to come to the selection grade lecturer with effect from 1/6/2001, and the selection grade lecturer scale of pay has been prescribed as rupees 12,000 to 18,300. Therefore, petitioner is entitled to come with the fold of rupees 12,000 to 18,300 with effect from 1/6/2001. The same having not been extended, the petition is put to sufferings. It is pertinent to mention here that such matter was on consideration by this honorable court in the case of Jatinder Kumar Pati, but for the same with effect from 1/6/1993. Therefore, this reason for not extending such benefit to the petitioner with effect from 10/8/1997 appears to be arbitrary, whimsical, and without any reason. However, it is stated in the counter that the above benefit is extended in accordance with the resolution dated 19/3/1990. It appears the said resolution has not been taken into consideration in its proper perspective. On a reading of the same, it would be seen that the claim of the petitioner is justified with effect from 1993 as claimed by him. This petitioner also explained the same in his additional affidavit that such fixation is wrong as per the law established by the Hon'Ble Court in the case of Sashikanta Mishra and others versus state in OJC number 4912 up to 1993 that the counting of the service is to be made from the date of its initial joining against the regular post. Therefore, the petitioner's appointment having been approved with effect from 1/6/1996 and the petitioner having ample qualification to its credit, the petitioner is entitled to the benefit of lecturer senior scale with effect from 1/6/93 and selection grade with effect from 1/6/2001. The opposite parties at paragraph 10 of the counter affidavit filed on 28/7/2005 have admitted that the entitlement of the petitioner with effect from 10/8/97 in the lecturer senior scale and with effect from 10/8/2005 in the selection grade, ignoring the claim of the petitioner from 1/6/1993 as senior lecturer and with effect from 1/6/2001 as selection grade, which the petitioner is entitled to. The law established established in the case of Sashikanta Mishra, which was confirmed by the Hon'Ble Appeals Court in SLP number 9140-9142 of 1997, wherein the state government challenged the above order and the same was dismissed as late as on 5/5/1997, applies to the case of the petitioner having at exception around second time. I believe, my lord, sir, those decisions I have given.
Yes, yes.
If that is not there, I will give a
What is there?
This is the crux and the entire case of mine. They have not disputed, they have admitted. But from a different date, though I am entitled to it according to the rules.
Yes.
Therefore, my lord, they have to grant it. They must have to refix it according to.
So the date has to be, according to you, it has to be 1/6/1986.
Yes, sir.
The date on which you were approved.
Approved.
So you have to calculate करेगा. Since you had an MPhil qualification.
Taking MPhil as my qualification, additional qualification, so that the
Well, the petitioner has prayed for different kind of prayers, my lord, which are not
relating to one cause of action, release of salary.
which are nowhere related to each other, my lord. One is relating to the payment of unpaid salary. One is relating to the sanction of annual increments. And thereafter, my lord, to fix his pay in the different pay scales under the career advancement schemes. And with respect to the unpaid salary and the non-sanction of the increments, the counter filed in the year 2005, it has been indicated, my lord, that in the year 2001, he was transferred as a lecturer from one college to another. And prior to that, my lord, there was a non-regularization of the service for certain period. Because for non-regulation of the same, my lord, that has not been done. But as it has been pondered by my lord, senior, my lord, that till date it has not been done. That information is not available with me, my lord. But it should have been. Because there is no such direction for stoppage of increments or other things, my lord. With respect to the second one, my lord, that is relating to unpaid salary, my lord. I think, my lord, that is also the my view is also the same, my lord, that it should not have been, because if for some reason the period has not yet been regularized, that requires regularization, and in the meantime, my lord, the petitioner age shows that, my lord, he has already retired in the he is retired in the meantime. Yes.
Undisputed.
So he is retired in the meantime. So obviously, my lord, the regularization of the period during the service period, my lord, that requires to be regularized. That is required to be done. And otherwise, my lord, it will also create a bottleneck for the sanction of the pension. But with respect to the career advancement scale, my lord, what I found, my lord, the difference in the previous case and this case, my lord, here it has not been sanctioned at all. And the ground what it has been taken by the opposite parties in this case, that it is for him to apply and that is to be processed. That has not been done. That is in para number 10 what my Lord Senior Malad actually referred to. In that para number 10 Malad we have stated so.
So that is all.
That's all.
All right, hearing concluded, judgment reserved. Sir, so you need not file a note.
Yes,
You may file a note,
yes,
just 1-2 page note,
yes, ma'am.
just to know your stand.
And may I have the liberty to show the exact status with respect to that increment sanction and the reference?
Yes, that will be helpful.
Yes.
In a chat, tabular form also, if you can.
I'll do that, ma'am. Because it should have been.
Parties may file their note of submissions and memo citations, if any, within a week.
Yes, I'll do that.
Sir, you need not file. If you want to file, you can.
After getting that, I'd like to clarify one thing for the favor of my learned friend. There is no discontinuation in the service. Service is there. Only they have not paid, that is the discontinuation according to that. I have been working without a day break. There is no proceeding, nothing else. I have been working day one from the day I was appointed till I was superannuated.
I'm supporting my senior Malad.
I'm sorry, I'm not able to understand your
No, rather, I'm poor in English. Sir.
No, that's okay.
Sir,
How to say that the discontinuation?
in that particular paragraph, what I just referred, my lord, there also, my lord, one sentence is also written that the principal undertook to regularize that particular period within 2 months.
That is between themselves.
So that is what, my lord, I'm submitting.
But I have to clarify, there is no discontinuation in the service.
Yes.
And because of want of increment, etc., there is some delay in payment, whatever it may be. That is why they review, sir.
All right. All right. Yeah, I recall. Qualify reproduction. Reproduction.
I don't know, 19.
After he should give a copy so that after that matter.
You give a copy too?
Yes, sir.
Yes. Yes, what? IA.
Lordship was directed to take instruction regarding the marriage of the petitioner daughter. Yes, it has been fixed to 12/7.
Then State Council has obtained instructions that the amendments made in the IA are correct. In that, the daughter of the petitioner is scheduled to get married on 12th of July. In such view of the matter, you are already on interim bail.
No. Earlier I was on the death of his mother, my lord.
In such view of the matter, this court is inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 3 weeks.
My lord. My lord. My lord, my lord, Geo Bagata किसी arrangement करो 4 weeks, sir.
All right, 4 weeks. Hello. अब जाओ हुए हम लोग.
Hon'Ble.
I don't know, 20.
My lord, lordship, in this matter, I'm through virtual mode.
Yes.
My lord, the matter is listed for hearing on my regular basis.
Lordship, I want a little last chance, man. Next week it will be produced positively. Today I have taken instruction. Today he is sending, so tomorrow it will be.
What do you say, Mr. Manohar?
Yes, lordship, on the.
I requested by Lord State Council. List this matter next week. CDB produced positively. All right.
I'm obliged, lordship. I'm obliged.
21.
Extension of time and surrender.
First time it was
No, second time.
second time. 1 week time is allowed.
Item 22.
Extension of surrendering time, my lord. First time.
First time 2 weeks.
Item 23.
Matters. Yes, my lord. Commission offense understand to the indicate that my lord. Earlier the petition.
Yes.
Earlier, my lord, the petition the constitution 3422, my lord. Here, my lord, 2 vehicle, my lord, and 1 seizure, my lord. In your lordship, last occasion, you granted 2 months interim, my lord. But their bill number.
Twice he has been granted interim bail for 2 months.
2 months, my lord.
170 kg of ganja, my lord.
170 kg, my lord, two bolero, my lord. Petition bolero is 68 kg, my lord.
When were you granted interim bail?
annex
3723 madam.
25
3723 madam.
3/7/23
2 years, 4 months already completed, my lord. Trials is not completed, my lord. No criminal accident, my lord. And this record, my lord.
What about the trial?
Trial, so out of 21, my lord, 3 witnesses are examined.
The petitioner is in custody since such and such date. In connection with such and such case, it is submitted that out of 21 charge sheet witnesses, only 3 have been examined so far. The total period of detention of the petitioner is more than 2 years. Though he has been granted an interim bail by this court on 2 occasions. He has surrendered to custody in time on both occasions without misusing his liberty. Taking note of the apparent delay in conclusion of the trial, I am inclined to take a lenient view. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 2 months.
Item 24.
Pass over.
Item 25. 24, my lord, I need some time, my lord. Next week. CD had been called for 24.
This is 25, I think.
Yeah, Purva matter.
Yeah, 24, let him come.
Yes.
Yes.
My lord, item 25, my lord, may I please allow? My lord, offense under section 20B(2)(c) NDBS Act, my lord, nothing has been seized from the possession of the petitioner, my lord. The occurrence took place on the 31/3/2021, my lord. It is alleged that while the SI of police conducting raid found 2 vehicles, my lord, one oil tanker and one Innova car, my lord. And while they detained the vehicle, some persons fled away from the vehicle, my lord. It is alleged that. And after submission of charge sheet, my lord, after completion of investigation, my lord, submitted charge sheet against one Ramachandra Bag alias Chandra Bag, who is already released on bail by my lord. And keeping investigation open under section 173(8), my lord. And on 11/3/2024, my lord, the present petitioner sold one Innova vehicle to one Guru Hon'Ble, my lord. Sold one Innova vehicle.
So what is the basis of implication of this?
Implication that seized vehicle was examined, that stands in the name of Damakilla, that present petitioner.
But there is no evidence that...
no evidence. 3 persons, 2 vehicle, all 3 fled away, one oil tanker and one Innova car.
Since when are you in custody?
My lord, 11/3/2024, my lord.
The petitioner is in custody since 11/3/2024 in connection with such and such case. The prosecution case is that contraband ganja weighing 1577 kgs was found.
15 টা ভুল আছে 1377 সেটা
1377 kgs was found stored in an oil tanker and Innova vehicle. The driver and occupants of both the vehicles.
My lord,
Innova রে 200 kg, oil tanker রে
total quantity আমি জীবন পাট পাট করে ওজন করিব।
No, ma'am.
এই গাড়ি কেতে সে গাড়ি কেতে পলা করে ওজন করিব।
It is mentioned, my lord, in the FIR.
ছাড়ো তো আগে। আপনার বেল দরকার না, আপনার ওজনের কেজি দরকার মত কে কইলে আগে? মিস্টার পন্ডা? না বেল দরকার তো? না কেজিটা
No, ma'am.
কেতে গঞ্জি কেতে কেজি ହେଲା?
No, no.
The totality ଉପରେ ଦେଖାଯିବ prosecution case cannot be segregated. Because that is one case has been registered. The total quantity alleged is 1377 kgs.
Yes,
man. The driver and occupants of both the vehicles are said to have fled away. Insofar as the present petitioner is concerned, it is alleged that he is the owner of the Innova vehicle in which some quantity of ganja was also stored. So, there is no evidence of the petitioner being present at the spot or that the vehicle was carrying the contraband at his instance. The co-accused, Ramachandra Bagh, has been directed to be released on bail as per order passed by this court in BLAPL number 898 of 2022. The petitioner stands on a better footing. Under such circumstances, I am inclined to allow the prayer. Let the petitioner be released. Seven search कर दो, condition कर दो, खाली cash security काट देगी, बाकी जा condition अच्छी कर दो.
Item 26.
May I please your lordship, my lord, basis of the implication confessional statement of the co-accused. And in the meantime, my lord, the said co-accused, namely Pratap Rana, though released on bail and also faced trial and got acquitted from the charge, my lord. And my lord, here, my lord, 63 kg ganja, and basis of the even if the preliminary.
Who was acquitted? Pratap Rana.
Pratap Rana, my lord.
You are Chandrasekhar Rana.
Yes.
Yes.
Upon his statement, confessional statement, my lord, the
Yes, it is found that he is the owner of that vehicle from the rejection of the tribunals.
All right. The petitioner is in custody since?
Custody, my lord, 12/5/2024.
12/5/2024 in connection with such and such case. It is alleged that 63 kgs of ganja was being transported in a car when it was detained by the excise officials. One Pratap Rana was present at the spot. Stop. On his confessional statement, the complicity of the petitioner came to light as being the owner of the vehicle. Yeah. It is submitted that in the meantime, in the original trial, the co-accused Pratap Rana has already been acquitted as per judgment passed by the learned judge, Special Court Phulwani, on 6/4/2023. Considering the above facts, I am inclined to allow the prayer for bail. Let the petitioner be released.
Item 27, may I please your lordship, matter of section 20B2C, 27A, 29A, NDPS Act. Petitioner in surrender on 1/5/2024 voluntarily. Well, nothing has been seized from his possession. In this case, my lord, two co-accused persons have already been released on bail. Petitioner is the local man. Nothing has been seized from his possession. Man. He has been implicated on the basis of the confession statement of the co-accused. And in the meantime, two co-accused persons have.
Laikon Hon'Ble.
Yes, lord.
We can pass the same order as Tapas Vishwas?
Yes,
Yes, lord.
Supplier.
Supply. Yes, same order.
Gotte player say cause title instead of Malkanagiri, it was wrongly typed as CORAM. Correction.
Learned counsel for the petitioner is permitted to correct the typographical error in the cause list. A cause title, sorry.
Item 28. May it please your lordship. Nothing was seized from the petitioner. Allegedly, the co-accused persons named him. Your lordship may kindly turn to page 11.
Page 11.
FIR.
Sir.
Second sentence.
Sir.
From the top second line.
Yes.
In front of the police staffs, the two accused persons revealed their names as Malik Bajinga, son of so-and-so, and Prahalad Khilo, so-and-so. And thereafter, sixth line, and they said that they arranged the contraband ganja from local villages which was being financed by one Arjun Hon'Ble. That means on the same spot his name was disclosed. Your lordship may kindly turn to page 2, page 10, previous page. The accused have been shown as Mallika Bajinga and Prahalad Khilo. His name has not been given as an accused, even though they said that on the spot his name was disclosed. Thereafter also your lordship will kindly see two statements of the independent witnesses as pages 20
and 23, 21, 22 and 23, 24. They also never disclose that these two persons, they said that they disclose their own name. They do not say that they disclose the name of the present petitioner.
ନାଇଁ ସେମାନେ ବି କହିନାହାନ୍ତି
କହିନାହାନ୍ତି ସେମାନେ ତାଙ୍କ ସାମ୍ନାରେ ଯଦି କହିଲେ ସେମାନେ ନିଜ ନାଁରେ କହିଲେ କିନ୍ତୁ ସେମାନେ କହୁନାହାନ୍ତି ଯେ ମୋ ନା ସେ କହିଲେ ଅର୍ଜୁନ ହନ୍ତାଳ ନାଁ accused ବି ଲେଖି ନାହାନ୍ତି ଆପଣ ଦେଖିଲେ on the spot FIR ସେ ଲେଖିଛନ୍ତି accused his name has not been given.
So anyway, he was the supplier, finance rather.
Yes. My lord.
The petitioner is in custody since
15/4/24.
15/4/2024. In connection with such and such case. The prosecution case, as revealed from the FIR, is that two persons, namely Prahalad Khilo and
Malik
Bajinga, were transporting contraband ganja in a motorcycle when they were apprehended by police. The total quantity of ganja
303 kg
was found to be 303 kgs. During interrogation, the petitioners, the said accused persons, gave out the name of the present petitioner as being the financier. Stop. Surprisingly, despite such information elicited from the co-accused persons, the name of the petitioner does not find place in the accused column of the FIR. Moreover, the independent witnesses examined by the IO have also not stated his name. Taking into consideration all the above facts, I am inclined to allow for bail. Let the petitioner be released.
Item 29.
Yes, Mrs. Jana.
Interim bail.
Main prayer is for interim bail.
Interim bail for 2 months because of the health condition of his 4 months baby.
Lordship directed to take instruction regarding.
So, there is no other male member to take care of the baby. The petitioner prays for grant of interim bail on the ground of illness of his child and non-availability of any male member in the family to take care of the child. The petitioner is in custody since in connection with such and such case. It is alleged that
since 21/8.
21/8/2023. It is alleged that he was transporting 50 kgs of contraband ganja in a car when it was detained by the excise officials. Prayer for interim bail has been made on the ground that the petitioner's minor child
3 months.
Again is
3.5 months.
minor child aged about
4 months.
4 months is ill and requires immediate treatment. Stop. There is no other male person available in the family save his old father, old parents, to arrange for treatment of the child. Lenot State Council has obtained instructions from the Inspector of Excise that the petitioner's child is in fact suffering from ailment and there is no other male person available in the family to arrange for its treatment. In such view of the matter, I am inclined to allow the prayer for interim bail. Let the petitioner be released on interim bail for a period of
2 months.
2 months. Yes.
Obliged.
Item 30.
This matter relates to NC. I informed to the Miss Bobita sir, she requested for pass over.
Pass over.
Item 31.
Item 31, similar order passed by this amendment.
कौन है जी similar order?
Cattle
Similar order cattle matter. कौन तो माने कौन?
cattle transporting matter.
आया?
Cattle transporting.
Cattle transfer कौन हो फिर?
Under section 379 411 Before IPC.
कोर्ट को आसुଛନ୍ତି ପଢିକି ଆସିବେନି ଫାଇଲ ପଢିଛନ୍ତି what is the matter what is the meaning of similar matter why are you not read the file and why are you not making submissions about the facts? I refuse to grant you the similar order. I will not follow the similar order. I will reject your application.
On behalf of my.
नहीं पढ़िକି ଆସନ୍ତୁ ପାସିଂ ଓଭର ପଢ଼ନ୍ତୁ ଫାଇଲଟାକୁ ପ୍ଲେସ୍ କରନ୍ତୁ what is the fact ପ୍ଲେସ୍ କରନ୍ତୁ yes pass over
Item 32.
लॉन्च पर ଆସିବ ପଢ଼ିକି ଆସିବେ ନିଜେ ପ୍ଲେସ୍ କରିବେ yes item 32 yes
32 may I please, my lordship. Lordship, on the last occasion, your lordship have directed the London State Council to obtain CD and verify the bail orders that the petitioner stands in the similar footing or not. I have annexed the bail order at Annex 2.
now see that community hall
My lords.
It was tagged in the community hall. The
ladies have been granted bail
yes, my lord. Two ladies has been granted bail and 4 to 5 persons have been granted on regular bail.
yes
What it seems from the local inquiry, they ascertained that these are the persons who are implicated, my lord.
the one Kartika Malik and Sashikanta Malik have been granted bail does he stand on the same footing
Yes, same footing, all over there. All were present there. Scuffle between
Kartika Malik is withdrawn Kartika Malik ଟା withdrawn ବାକି ଶ୍ରୀକାନ୍ତ ମଲ୍ଲିକ
police persons.
police କୁ ବାଡେଇଥିଲେ
Yes.
firing କରିଥିଲେ
No, firing is from the police side.
not Kartika Malik also withdrawn Shrikanta Malik also withdrawn
My lords, previously they are filed. They have one is withdrawn and one is not placed, my lords.
so who has been granted bail only the ladies have been granted bail
My lords,
no male person
Granted anticipatory bail.
any male person has been granted bail
My lord.
any male person has been granted bail
yes, my lords.
Yes, Mohan Chandra Malik.
Nice, sir.
Page
and
30,
another-
my lords.
Page 30, 31.
page 30 is Mohan Chandra Malik
And
regular bail
Malik and this is a regular bail, my lord.
you what do you say if he stands on the same footing we can direct him to surrender and be released on bail
Yes,
basically it is regular bail
Some-
ତାପରେ ସେ ଅନୁସାରେ accordingly change କରିଦେବେ ହେଲା custody part ଟା ପଳେଇବ is କଣ is apprehending arrest and such and such ବୋଲି କରିକି କରିଦେବ page 30 ରୁ ଯୋଉଟା ଅଛି ସେଇ ଅର୍ଡରଟା କରିବେ ନା ତିନିଟା ଆଉ ଦିଟା କିଛି ନା ଖାଲି ଆସିଛି ଇଏ ପାଇଁ ଆଉ ଦିଟା already disposed of 33
Item 32.
I filed IF for correction of court name, my lord. In place of first additional session judge, fast track Baleshwar, it would be ad hoc additional district and session judge, fast track FTSC Baleshwar.
କୋଉ ଜାଗାରେ ଥାଏ ଆଡ୍ ଥାଏ ମାନେ ଆଇଏ ର ଯୋଉ ଅର୍ଡରଟା considering the submissions the order dated 14/5/2024 passed in IA number 26 of 2024 is modified sanctions yes
Item 34.
Interim order to continue.
interim order to continue
May I please, Lordship? 34, my lord.
cancellation of bail
Cancellation of bail, my lord, which is passed by my lord on dated 16/1/2024, my lord. By violating the condition, sending the rented gundas, attend the construction.
who was granted by Ashish Dumdum the petitioner is the husband of the daughter of the informant who is already killed yes what has happened
Well, they are sending the rented gundas to threaten the petitioner and also their family to withdraw the cases, which has been lodged.
to issue notice
To that effect, there is no such evidence. He has not annexed.
Photos are there. Photos are there.
He should have annexed.
will issue notice issue notice to the opposite party the parties opposite party number 1 by registered post with AD making it returnable within 4 weeks requisites be filed within 3 working days let's just matter
30th July.
नेता पूर्व लिखा State Council shall obtain instructions
in the matter? Does this matter on 30th July? Yes, sorry. Password what the Rajadiki option? Password matters, anybody available?
So item number 16,
Sure. Tabre?
item number 24, item number 30,
Sure. After recess, we'll take up. Password rakhi ki tapre weekly ku jiba. Let's this matter next tomorrow. Tomorrow. If it doesn't appear, we'll dispose of.
password item number 24,
24 में April victim is examined, my lord.
Your lordship, at one time, your lordship called for the CD. Comes next week, any day.
Yes, my lord. But CD may not be required, my lord. I have given the deposition to lordship, and
The last date, your lordship wanted to see the 164 statement and medical exam report, all those things, my lord. Though deposition is there.
deposition is very clear that in paragraph 2 and 3, my lord, that is relevant to. Present petitioner name is Krishna Khilo, my lord. One Hon'Ble and Rajesh Khosla is the prime accused.
Who are you?
My lord, I am Krishna Khilo.
The principal accused is Prakash.
Prakash and one Soros. Main allegation, my lord, one Soros. Prakash and Soros. Both have committed the rape, my lord.
But you were present at the spot.
Yes, my lord. Only present is I have present.
You were present at the spot, and he says that when I returned home with accused Krishna Khilo and Prakash Hon'Ble around 6 p.m. tapre itedi.
My lord. No possible comment.
Thereafter again, allegation of rape is against both Prakash Khilo and that
Prakash Hon'Ble and Soros Khosla.
Prakash Hon'Ble and sorry.
Soros Khosla. And Soros Khosla granted bail, my lord. By lordship. सेटा से 164 को देखेगी लॉर्डशिप देइथिले डिपोजिशन रा असला
No, Mr. Party.
Yes, lord.
Okay, time daba. Next week.
ठीक है 9 तारीख lord. Because
up-to-date case diary we obtained as directed earlier. Let's this matter next week. I'll just go through the 164 and then.
Yes, my lord.
If Soros has been granted bail, then there's no reason why you shouldn't. But let us see the 164
again. Praying for 9, my lord.
9th.
Public.
password item number 30,
30, yes.
Union of India.
You have given the copy.
Oh, yes, my lord.
Where is she?
I also informed her, my lord.
With this matter tomorrow. Indicating the name of Kagudichan.
Office से दान दिया इतना but I informed to Miss Bobita sir.
तो कौन करे? You will tell her that tomorrow it's coming up. और कौन करे जो?
Tomorrow sir I will inform.
Yes.
password item number 31,
31. Yes. पढ़ले. कौन पढ़ले? पहले कौन?
Illegal transportation and theft of cattle.
Yes.
Theft of cattle and illegal transportation.
Illegal transportation of
My lord.
cattle. You will be transporting cattle. Why should you be granted bail?
And the other
illegal transportation. तो illegal transportation जो तो कौन काहे की bail पाइबे?
other accused are
No, other accused जाई तरंती. Other accused से आपन को simple कौन आपन को कौन पढ़ले आपन फाइल दे. आपन को टाइम देले कौन पढ़ले आपन?
falsely mentioned.
कौन false किन जानियो false लेगे? कौन पे falsely mention करिवे? ताको आपन ऊपर ना कौन आगे से पुलिस ऑफिसर के?
Yes, villagers as villagers माने मो ऊपर मिछरे क्लेम करती.
सुने काहे मिछरे कहले आपन ना खोजी आपन को मिछ कहले आपन ना काहे?
Cruelty manner of
When you come to the court, be ready with the facts. Simply এটা covered matter সেটা similar order may be passed করলে হবে না এই কোর্টে
All right. इधर pass कर दे. I may pass the similar order, but it is not for you to claim it as a matter of right. Same order कर दे. Yes, Mr. Mishra.
No, same order.
Yes. Sharila. Supplement. Or weekly.
Weekly list item number 1.
Item number 1 password also on behalf of Budhiram password.
Item number 1.
Again, password.
You are appearing for whom?
Appeal back. Respondent. Budhiram Das.
This is a password matter.
Password.
Or
Appearance.
Nice.
all right, password.
There was probably no mention in the cause list.
No, there is mention opposite party, respondents are appearing. They used to appear through Mr. NC Pati.
No.
The change it will
No, he's associate, Budhiram.
See, associate. Take a wait, Karjiba. Yes, Mr. Das, let us wait for a while.
Yes.
Yes.
Item number 2.
Item 2.
Plaintiff is an appeal against a reversing judgment. Plaintiff suit was decreed. Plaintiff suit is for declaration of right and interest and for permanent injunction, restraining defendants not to come up with the suit land or not to interfere in their possession. It's a passage. Now, some facts are necessary. Parties are related, different related as Mousa and Putra. So I purchased 100 decimals of land from Sanatan South for construction of house. To the south, there is Mahadev, the brother of Sanatan. So towards that passage, I have purchased only 0.10 decibels, which connects the main road. Now he has also constructed his house. Now there is a boundary wall on either side. It is Pachi Rahila. Now I purchased land in 1984. Thereafter, while I was staying there, I was living with my husband, came back and resided there. After my husband's death, all of a sudden, the adoptive grandson, because that Mahadev had only one daughter and two sons. Sons were staying at Bhubaneswar. So Kokula is the daughter. Kanu is the son-in-law. Now the adoptive grandson, he started creating disturbance. He locked the gate. So I had to scale through. My son had to scale through the gate at night, and thereafter the police complained and the suit was filed. In fact, when he locked the gate, the grandson disclosed that the sale deed for that passage has been cancelled by the vendor, Mahadev. And so I obtained the certified copy, hence the suit. Now, the trial court decreed the suit, holding that once the recital of the sale deed is clear and unambiguous, no further evidence under section 92 is necessary. Furthermore, the defendants are permanently restrained. So all those findings are quoted in my note. Now, right since the trial court to the appellate court to this honorable court, the status quo in respect passage has been maintained right since 2011. Kindly see the order dated 9/60. There is no obstruction now. Order number 6.
Yes.
Para 5.
The respondents are hereby restrained from making any disturbance in respect of the suit path.
Yes.
And also not to put any obstruction in the iron gate. Voila. See, this is continuing.
Now the question is, the appellate court.
Why was it reversed?
It was reversed on their appeal. Appeal was filed by.
On what ground?
On one ground, that even if the sale has been, even if
there is a recital sale deed, still then a party can question that by leading evidence. Number two, the property which you say is vague and not identifiable. To that, my submission would be, source of the trial court's finding is that the very property which you sold has been cancelled. So you know what is the property. Even otherwise, by your boundary description also, that will prevail. If the schedule of land is vague, if there is no sketch map, then the boundaries will prevail.
Order 7 Rule 3.
Later Justice D. Rasku judgment achi. The parties know what for they are litigating. Another thing is that the
Can we come to that finding of the trial court? I mean, appellate court or judgment?
note कर दी देंगे.
Note court. You filed a note. Written note filed by the appellant, yes. How can a sale deed be cancelled?
That is the finding of the trial court that the sale deed cannot be cancelled unilaterally. And that is also the admission of the counsel that no, it cannot be cancelled unilaterally.
Yes. He has gone on to find that if there is no endorsement by the sub-registrar, and then
Section 58.
passing of consideration is also not proved.
The passing of consideration. One part is that there is no endorsement of sub-registrar under Section 58, that money was paid before the sub-registrar. To that effect, the evidence of the plaintiff is that all the transactions were made by my husband. Money was paid by my husband before the sub-registrar. That evidence has not been taken in cross-examination. Number two, I have also laid evidence to the effect that while my husband was transferred, both the vendors, they are related to my husband and the widow. Both the vendors are related to my husband. They are nephews, or say uncles. So during my husband's transfer from this place to other, that original deed might have been lost or misplaced somewhere. Misplaced. The evidence is misplaced.
A certified copy will be available from these.
That is certified copy, Exhibit 3.
Yes.
So here, the grandson and the main contesting defendant, he produces the original sale deed, saying that no, original sale deed is with me. Therefore, the lower appellate court says that since the original comes from the defendant side, that is to believe. Now, as far as that is concerned, there's a decision of our High Court that a statement of a person, dead person, against his pecuniary interest is binding on his successors under Section 32(3) of the Act, the Evidence Act. That is judgment kal deegi.
ଆପଣ ସାଇଟେସନ ରେ ରେଫର କରିଛନ୍ତି କି?
ଆଜ୍ଞା
ଅଛି ତ ଜଜମେଣ୍ଟ ଅଛି।
ଏଇଟା ଦେଇନି।
Yes.
And one more thing. I think I had shown you lots of the photograph.
That photograph or you had shown me a photograph with a iron gate.
Yes. How button I put it.
But do we have a map? Sketch map?
Yes. That is also part of the record. A good page.
Hello? To this portion, this passage.
Yes.
This is the bone of contention. Contention.
There is no other passage.
You are Snehalata Sahu.
I am Snehalata. I have purchased from Sanatan, who is in the middle. ତଳେ ରହିଛନ୍ତି ସାଉଥ କୁ ରହିଛନ୍ତି ମହାଦେବ ଗୋଟେ ଭାଇ ମଝିରେ
ଏଥିରେ ସେ ପାର୍ଟଟା ନାହିଁ ଏଥିରେ ସେ ପାର୍ଟ
ଅଛି
ଏଟା ରେସିଡେଣ୍ଟ ଅଫ ସ୍ନେହଲତା ସାହୁ ରେସିଡେଣ୍ଟ ଅଫ କୋକିଳ ସାହୁ
କପିଲ ନର୍ଥ ତଳଟା ଅଛି ମହାଦେବ
ନାଇଁ ଏଠି ନାହିଁ ଦେଖୁନ
କୋକିଳ ସହିତ ଡକ୍ଟର
ଓକେ
ଏଇ ପାସେଜଟା ଡିଭାଇଡେଡ ଥିଲେ ମୋର ସନାତନ ଆମକୁ ଏଇଟା ଦେଲେ ତଳଟା ଦେଲେ ତଳ ଗୋଟେ ପାସେଜ 6 ଫୁଟରେ 5 ଫୁଟରେ 87 feet.
Is there any other way of ingress or egress?
So therefore, under Section 4 of the Easements Act, I would also have a right to pass through the gate. Now, this position continued right from 1984 till date. All of a sudden, in 2011, after my husband died in 2008 or 7, so 2011, this trouble started, saying that my grandfather had cancelled it. And moreover, during the mutation proceedings, he had disclosed that I have cancelled the sale deed. Therefore, that plot was not mutated in my name as a separate plot. And the trial court said that even if that is so, you have a right of way.
I think that's all about it. That is all.
I just want to show the photograph that envelope. I don't get it.
नहीं छाड़ो मैं देखी थी सब देखी थी
sorry.
But the map is clear.
If you bond this is the only passage. A choro de which oh butter nahi. And here is the iron gate. In fact, to the left of the iron gate, they have got enough parking space, car parking space. They are also using their passage.
Nothing but a clash of ego. That is why I had, I think, I had referred it to the mediation probably, or it was earlier referred.
It was earlier referred. There also I persuaded them. But some of them, there was a counsel who was appearing there.
Mr. Bhuya is himself a mediator. Were you not?
Yes. In fact, I was suggesting to them before this mediation cell.
No, I can hear the matter finally, I can dispose of.
Yeah.
What Mr. Bhuya for a passage and ultimately he will have a right of way under the Easements Act.
During mediation, I was not there. It was a transfer bill.
No, that I understand.
But what I was made to understand, Milord, that in the mediation, the mediator tried his best persuading the appellant for a conciliation or a settlement. But it failed because of the non-cooperation of the appellant. But the fact remains that the mediation report does not reveal and it cannot also. Under the rules, he cannot say.
He cannot comment on the conduct of the party. Yes. But then I'm just posing the question to you. I'll be happy to go into it. There's no issue. But this is even otherwise he will have a right of way under the Easements Act. Can you deny it?
Exactly.
And if he is able to satisfy that there is no other.
Yes, Milord. Whether the pleading reveals that it is a case of easement only.
No. Alternatively.
Alternative pleading is also not there. Milord, I'll take your lordship because that is the crux, Milord. If a person having a residential house, having no access save and except the suit land, at least forget about the law. The conscience says that he must be allowed to access to his house. That is the conscience, at least in all the person of the world will to his side. But subject to if there is no other access. Neither the pleading reveals that it is a case of easement, nor there is any pleading, evidence to that effect. I'll take your lordship, Milord. Why it is a case of declaration of title, not on easement, Milord. It is not a question of declaration of right. It is a question of declaration of title. Right. If proves before your lordship, at least from the pleading, that he has made out a case, your lordship has rightly posed the question, order 7 rule 3. Now he says that I have purchased this 10 decimal, 010 mill. Lord, kindly consider this 10 decimal can be considered 1 kodi into 100 kodi or 10 kodi into 10 kodi. So the plaintiff lacks the particulars. There is no sketch map, as my learned friend has shown to your lordship, my lord. In the plan, there is no identity of the land, my lord. For passage, an identity is a sign of honor. That is right from 59 Patna. It is there, my lord.
बहुत डिसीजन अछि ऑर्डर 7 rule 3 पर बहुत
my lord, order 7 rule 3 specifically claiming passage, my lord, because it has to be defined.
Yes.
Even if your lordship sees in the planned schedule, my lord, there is no configuration given, whether it is 10 kodi into 100 kodi or 5 kodis into 200 kodi, at least to make out that it, so that the court can presume that this is the passage and an effective decree can be passed. That is not there. The lordship may kindly see the, before I address your lordship may kindly see the decree. And the plan, because the plan, I am showing you.
You want me to see the plan?
Yes.
So let us
Your
have the
lordship
LCR.
will turn to.
No, no, तुम LCR टा खोले.
Again. Plan टा देखिए सर देखो देखो.
The persons whose I am always under this difficulty. I have also brought it to the notice of the scanning committee, digitization committee. Where the persons who are scanning it, they do not know what is planned and कौन था बात
हाजिरा उड़ा भी कर दूँ
खाली हाजिरा वाला
सीटा सारा प्रॉब्लम से भी सर मिस्टेक रहा मैं I was the only person who said and when we started in Ganjam this digitization process we segregated the files B B1 C जो तर हाजिरा फाइल आती है तो चीज़ फोड़ दियो दरकार नहीं छोड़ा ना क्यों डिजिटाइज करो मैं सब डिजिटाइज करूँगा हाजिरा फाइल आती है प्लेट नहीं
जीरो से कोई सी फाइल टा अलग कर दो even before hearing started.
Yes. अच्छा हो शेड्यूल ऑफ सूट लैंड
आगे
मुझे निकालता हूँ सभी खाता नंबर इतने सभी प्लॉट नंबर इतने करस्पोंडिंग टू हाल खाता
सर ठीक है सेठी देखो तो प्लॉट नंबर टा कितना अछि
प्लॉट नंबर अछि पूरा 5645 of 9251
by 3 बोते
आउ 3 नहीं खाली सेठी अछि.
Then your lordship may kindly see there is a they have given out of 120 decimal 10 decimal and that they have furnished a boundary miller.
North, south, east, west.
North, south, east, west. Can it be said that a passage without any description of the length and breadth, a passage can be presumed? That the appellate court has taken note of. I'll take your lordship to that. Lordship may kindly say, and another thing, this they claim a declaration of title, not a declaration of right of issue.
Yes.
It has got two distinct and different class of suit, Miller. Lordship may kindly see paragraph 3. They say we are using it as a pathway. So what I impress your lordship, Miller, for claiming a pathway.
Paragraph 3 नहीं आउट ऑफ
No sir, म्हणते की पेन दे underline करूची.
Para 4 अछि.
Para 4.
For her use as pathway extending north.
Miller. But there your lordship also kindly find the length and breadth has not been furnished. So even assume your lordship passes a decree, Miller. This 10 decimal, he can say that in front of my house. Your lordship may kindly visualize. Yes. And I may say that it is behind the plot. So what I try to impress your lordship, there cannot be any effective decree, executable decree, in absence of the definition of the property.
So no application was filed under 26(9)?
No. That once you claim that something as a passage or a right of pathway, its length, breadth is required to be given, so that the court will be in a position to assess whether such a pathway is necessary or not. That is one, which the Learned Appellate Court has taken note of. Second and most glaring thing is that there your Lordship has seen there is a boundary furnished in the plaint. The boundary furnished in Exhibit A and 3. Exhibit A is the original shell deed with me, and Exhibit 3 is the certified copy they have furnished.
Yes.
Kindly compare that. It varies. That boundary differs. And if your Lordship see the PW evidence, it is something else, which the appellate court has taken note.
Yes.
Lordship, kindly come to appellate court judgment.
Yes.
Lordship, kindly come to paragraph 10. Page 9 of the paragraph 10. The second foremost controversy is on identity of the suitant. The plaintiff sought for a declaration of her title over acre 010 decimal of land out of total area of 120 decimal with certain boundaries out of Sabic plot number so and so. Sabic plot number, Sabic khata number so and so, Sabic plot number 5645 corresponding to Hal khata number 2341, Hal plot number 5645 by 9251 with boundaries. North Plaintiff, South Road, East Badrinath, West Mahadev. But Exhibit 3 shows that the plaintiff purchased plot number 5645/3 pertaining to khata number 2593, area acre 010 decimal out of acre 120 decimal. Eastern side with the following boundary: North Vendi, South Road, East Badrinath, West Vendor. The case of the plaintiff is that this is a piece of land constituting a road. So there is no clarification as to how the purchased plot of 5645/3 correlates to the suit schedule land as indicated in the schedule of the land in the plan. PW1 in para 15 of her evidence has categorically reported that she had purchased Sabic plot number 5645/3. She further stated that she has filed the Sabic ROR of that plot, but in fact, no such Khatiyan ROR was proved by the plaintiff to show the existence of Sabic plot number 5645/3. It is further evident from our evidence that the sketch map showing a road disputed land has been attached to Exhibit 3. In fact, no such sketch map was attached to the shell deed Exhibit 3, which falsifies the version of the plaintiff. The boundaries as deposed also differs between the description of the suit land in Exhibit 3 and description given in the court. PW1 deposed that her 10 decimal of land is bounded by East Dilunanda, West Haramisra, North Kokle South, and South Mahadev South. In view of such evidence, it is crystal clear that the plaintiff is not aware as to which property she purchased under Exhibit 3. The Learned Counsel for the respondent, when argued and also draw the attention of the court that when there is defect in plot number, the boundaries will prevail over the plot number. Such proposition of law cannot be disputed. But in the case at hand, there are two sets of boundaries appearing before the court, that is given in the plaint, schedule, and a different boundary stated in the oral evidence by PW1. On the other hand, the schedule does not contain any dimension, length and breadth, either in Exhibit 3 or in schedule of the plaint, and the alleged map showing road also was not annexed to the cell deed exhibit 3. It is well settled in the decision reported in AR 1959 Patna 306 that no effective and executable decree can be passed with respect to the suit schedule land, as no map was annexed to the cell deed or the plan. When there is no dimension, it is very difficult to pass an executable decree because the suit schedule land of acre 010 28 and decimal may be different in size to constitute a road, and as such, no effective and executable decree can be passed in absence of the sketch map and specific dimension. So this is the findings of the Learned Appellate Court regarding the Order 7 Rule 3. Now, I will take the other side of my limbs of argument. My lord, it is a question of declaration of title basing upon a cell deed. The certified copy thereof has been admitted as exhibit A, proved by the plaintiff without leading any Exhibit 3. Exhibit 3. Exhibit A is the original published by the department. The plaintiff filed the certified copy on the plea that the original is lost or not found. My positive case in the written statement that due to non-payment of consideration money, it was cancelled in 1988 unilaterally by the vendor, and there was no passing of title, no delivery of possession.
No, passing of title without there being passing of consideration is one part, but unilateral cancellation of sale deed
is another part. Unilateral, your lordship may kindly consider it for the moment that may not take that the cancellation as valid. Now it is a suit for declaration of title is to prove. A sale is always backed by consideration. Section 54 of TP Act says. So unless there is a consideration, there cannot be any valid sale. Forget about your lordship that the defendant has cancelled it unilaterally. Now he has said that I have purchased it under Exhibit 3. He said that the consideration money was paid on the date of registration before the sub-register, that is the PW1 has stated assertively before the court.
The passing of consideration according to you has not been proved.
Passing of consideration has not been proved. And that the appellate court has taken note of. And the third glimpse of my submission before your lordship, when a title is disputed, the suit has to be filed within a period of 3 years. Unless he proves that I am in possession, or he was in possession, the plaintiff was in possession 12 years prior to the filing of the suit. That is the mandate of Section 27, read it, Article 64 and 65. Now, my lord, what the plaintiff himself given the evidence that he purchased 2 pieces of land, 100 decimal for the purpose of construction of his house, that is, and 10 decimal this for the, he says that for the purpose of passage. He filed a mutation. It was purchased in 1984. A mutation was filed in the year 2006. In that mutation proceeding, the vendee and filed by the vendee, the vendor appeared. The vendor said that I have cancelled, there is no delivery. The mutation proceeding only allowed to the extent of 100 decimal purchased by him, 10 decimal negative. That means the cancellation, and that I am disputing his title through sale deed is known to him since 2006. He filed the suit. Lordship may kindly see, the suit was filed in 2012. In 2012.
No. When was that mutation?
2006. That is exhibit. Lordship will see.
So suit filed in 2012.
12.
According to you, it came within his knowledge
in 2006. So 3 years he should have filed this. Now, Lordship may kindly say Section 3 of the Limitation Act.
Section 3 कौन माने even if he is not taken by the party तो
No, no, section 3 है sir obligation of the court.
to look into the limitation aspect.
Again, whether the defendant has taken the plea or not, it is immaterial. It is the court, the obligation of the court to see that every suit, proceeding or application is within the stipulated period of limitation. Now, that mutation, your lordship will see exhibit D. Each mutation, I have given the entire mutation records where it was negative.
Yeah, we'll find it out, but now, right now. I'm not getting it. It must be there, but I'm not getting it, you may say.
Exhibit D, though I
You have
a certified copy.
hard copy ଥିଲା ହବ hard copy ଅଛି LCR ର ଅଛି ତ
Your lordship will see exhibit D is dated 10/10/2006.
yes Mr. Mahapatra yes mutation ଇଏର order ଟା ତ
ଆଜ୍ଞା order ଅମିନ ରିପୋର୍ଟ ସବୁ ଦେଇଦେବି
ସେଟା କେତେ exhibit କେତେ
D ହେଇଛି sir.
Yes, sir. The petition is Mahadev Sahu received all the
110 ପାଇଁ ଆପ୍ଲାଏ କରିଥିଲେ ସାର୍ ଦେଖିବେ ପିଟିସନରେ ଗୋଟାଏ ରୁ 100 ଗୋଟାଏ ରୁ 10 100ଟା ଆଲୋ ହେଲା 10ଟା ରିଜେକ୍ଟ ହେଇଗଲା I mean report is also there.
I want to see the final order.
Sir,
ଏଥିରେ ଅଛି ତ
final order ଅଛି ସାର୍ ତାର ଦେହ 100ଟା ରେକର୍ଡ କରିବା ପାଇଁ
I want you to do one thing. You place the final order, I will hear. ଆପଣ ପଢିଛନ୍ତି ସେଥିରେ କିଛି ଫାଇଣ୍ଡିଂ ଦେଇଛନ୍ତି କି କାହିଁକି ରିଜେକ୍ଟ ହେଲା ବା କଣ
ଆଜ୍ଞା 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 ସେଟା ଦେଇ ଦଉଛି ସାର୍ ପଢି ଦଉଛି verified the registered cell deed dated 21/2/94 21/2/94 is the impugned cell deed. The Amin Sri KB Sahu is directed to conduct field inquiry and a report. Accordingly, the course errors notice to all concerned कही देले तापर हैला the case record is taken up today. General notice duly published and no objection has been received during the stipulated period. Individual notice to the parties have been duly served and no objection has been received from any other party. Petitioner is present and had verified the document produced by the petitioner which reveals that he has purchased the land RSD number so and so dita cell deed dele record kale 100 dismill with the report of RI KB Sahu would form part of the case record. In view of the aforesaid facts and findings, mutation is allowed to the extent as above. Sir, ଟିକେ mutation ସେ ଅମିନ ରିପୋର୍ଟଟା ଯୋଉଟା ପାର୍ଟ ଅଫ କହିଲେ ମୁଁ ପଢି ଦଉଛି ଦରଖାସ୍ତ କରି ମହାଦେବ ସାହୁ ପିତା ଭାବ ସାହୁ ନା ନା ଏଇଟା ପିଟିସନଟା ଅମିନ ରିପୋର୍ଟଟା मैंने रिपोर्ट का
ପ୍ଲେନ୍ ଥିଲି ଅଛି ପ୍ଲେନ୍ କିଛି କହିଛନ୍ତି
ହଁ ମୁଁ ସେ ଦିଟା ପ୍ଲଟ ଆପ୍ଲାଏ କରିଥିଲେ ଆଜ୍ଞା ଦିଟା ପ୍ଲଟ ଆପ୍ଲାଏ କରିଥିଲେ 100 ଆଉ ଗୋଟେ 10
I will look into the LCR while passing the judgment.
100ଟା ଆଜ୍ଞା ତାଙ୍କ ନାଁ ରେକର୍ଡ ହେଲା 10ଟା ରିଫ୍ୟୁଜ ହେଲା
He that is project parrot 6 of the plane that my husband was looking after during the transfer from place to place, and as such, that plot was not muted in favor of my plaintiff.
ତାଙ୍କର ଆଜ୍ଞା
Transfer report card good to ବାହାରେ
ଯାଉ
ଲେଖି ଦେଇଛନ୍ତି
2006 ରେ ଆଜ୍ଞା ଏଟା ରିଜେକ୍ଟ ହେଲା ମୋର ସବମିଶନ ବିଫୋର ଲସି
there are two cell leads 105984 106084 both the brothers sold it consecutively by the same number. More evidence also that when my husband moved from place to place, it might have been misplaced. Now somehow it pops up from him. In between, before filing the suit, when he locked the gate, the grandson locked the gate, he said that we have cancelled it. Therefore, you took up the certified copy.
Cancellation টা your lordship will see what I would try to impress me lord that cancellation was made known to her in the mutation proceeding. In the mutation proceeding, I objected that I have not sold and it has been cancelled in 1988. Basing upon my objection, the cancellation, the mutation officer refused to mutate 10 decimal, but allowed 100 decimal. So that is my submission. On that day, the cancellation was known to him. His possession, that he is not in possession, and I am disputing his possession is also known to him. So any suit should have been filed within 3 years. That is 2009 at best 10 million. But it has been filed in 2012. Now my further submission before your lordship, my lord. Now the appellate court considered that it is a suit for rental and basing upon a piece of land, the identity of which is very much confusing, and recorded a conclusion that no effective decree can be passed. Now, your lordship, kindly pause here for a moment. So he is our, at least of the fact, because of the appellate court judgment, that my identity as disclosed in the plan is vague, and despite your lordship's power under Order 41 Rule 27, no application has yet been filed to depute at least a commissioner to find out whatever the configuration I
asked at the beginning.
Mila. No, neither in the trial court, nor in the appellate court, nor even in the second appellate court invoking your lordship power under Order 41 Rule 27.
Yes.
Now, therefore, my submission, there cannot be no escape from coming to the same conclusion as that of the appellate court, that because of the vagueness of description of the suit property, no executable decree can be passed.
That is all.
That is all. And in order to what I have submitted, Millard, I will give a note, short note with all.
You have already given a note, Mr. Samitran.
Lord has given. He is to submit a copy to me.
Hearing concluded.
Lordship will kindly suit paragraph 20 and 21 of the trial court judgment, where the learned court has said that this is the very property I have compared to which you have sold.
Yeah, I'll go through. Hearing concluded.
Point of law खाली से कहले टंकाटा दिया जायछि सब रजिस्टर सामना निजे भेंडी कहले तो लॉर्डशिप will see section 50
yes
of the registration act जदि टंका दिया हेबो ताले registration is bound to registering officer is bound to endorse the money has been paid, and that is absent in exhibit 3 and 8. So the language used in section 58 is shall. That is mandatory.
That no consideration money was paid. That was put to the defendant. He says, I don't have any knowledge about that. I do not know where the vendor was paying. Then was his grandfather. And he is dead.
All right.
এটা
That is his evidence.
ତାକୁ ଦେଇଦେବ ନା ନାଇଁ ଆମର ଅଛି ନା ଏଲସିଆର ନାଇଁ yes hearing concluded judgment reserved parties may file their note of submissions and memo citations if any within a week.
Milord, plain copy shall I furnish also? Plain.
No, the LCR is here. I'll only have to find it out because while scanning they may have done it either.
But the one prayer is to cancel, to declare that the cancellation deed dated 12/102 of 88 is null and void. Data could trial court tell it is ab initio void. You cannot be declared, cannot be cancelled unilaterally. Gotte Vajak judgment dikhini, the moment the sale is executed, all rights pass.
All right.
Out of cancel kariyo.
Yes. So item 1, has anybody come on for the other side?
It is
Otherwise we'll pass it over for the day, we'll take it up tomorrow. Morning orders are more. Pass over for the day. All right. Yes. Yes, item 3.
Item number 3.
I am passing out the judgment of the evidence side.
Sure, okay. Item 3. Who's for the?
Item 3, Milords, I am for the appellant, Milords.
Yes.
I may be pardoned, Milords. I am held up in another, that's why I am in BC, Milords.
Yes. Who has died?
Milords, respondent 1, we have filed 3 IAs are on record for substitution of respondent number 1, Milords. IA number 327, 328 and
When did he die? When did he die?
He says.
When did respondent number 1 die?
Milords, I do not have my file with me right now, Milords. If you lost it.
Paragraph 3.
Died in the year 2004.
4.
When did you file this?
In 24.
In 24, 20 years. Why should I condone the delay?
Milords, just for the sake of interest.
We'll do one thing, Mr. Rao will do one thing. Let us hear the appeal. If respondent number 1 is a necessary party, then we'll condone the delay and we'll substitute.
I don't know.
Otherwise, if it can be severed, then we'll delete respondent number 1. The suits will stand abated as against respondent number 1. As requested by learned counsel for the parties, list this matter next week. Week commencing for final hearing.
Week commencing.
It has been admitted. Substantial question of law has been framed.
It has been admitted, Milords.
So LCR is there.
Milords, LCR is there, Milords.
So we'll hear it finally. At the time of final hearing, if we find that respondent number 1 is a necessary party, then we will allow it. Otherwise, we will not. All right. This is matter next week for final hearing.
Week commencing.
8th July. Yes.
Item number 4. Item number 4. Discuss number 76 of 2004 has come for orders.
Leave to file
76. Yeah, got it, Parad.
Items, miss case number 76 of 2004, no? Why this permission is required?
Because during pendency of the appeal in the lower appellate court, defendant of 3 died. I am the defendant respondents. Appellant did not substitute. And also from our side, no effective steps are given informing the court that defendant of 3, respondent number 3 has died. Therefore, his legal heirs, appellant number 345 before my lord in the appeal, has filed this application seeking permission to prosecute the appeal.
What is the law in this regard?
151, I have filed.
151.
151, I have filed. He has filed the objection. In the objection, there is no.
Yeah, but where is he? For the other side. Item.
And I have said that during.
No, Mr. Parija was there on the last.
He is here.
My lord, the fact is not like that. He was unheard on 99, October 29th day. He was unheard, so he has not died. During that 7 years, the appeal has been disposed of. After that, he has made a party, him to here. Here he made party. Now he is taking that he has died during 99 and appeal will apply.
Serious objection.
To go to that point.
only he has prayed to get a permission to proceed with the appeal. At his risk, he may be allowed to proceed with the appeal. There is no difference.
Applicant 3, 4, 5.
In this case, 76 of 2004, this is an application filed by the legal heirs of deceased respondent number 3 in the lower appellate court. It is stated that respondent number 3 died
during the 29 during super cyclone.
Direct
on the day of super cyclone.
So कौन करियो से
नहीं मर जाई नहीं
अनाले तो आपण को इनक्वायरी की करछि
सिविल डेथ ही जो अब 7
वर्ष है अभी के हम टाइटल अपने सही गला अब हम सब्स्टिट्यूट काई करियो
सब्स्टिट्यूट करन
नहीं सब्स्टिट्यूट अपन कोई ना you have done rightly you have not substituted. Why should you substitute somebody whom you do not know that or not? And that's why the period has not gone. So why should you do that? But now let them
let them do it on their risk.
लिख ले 19/10/1999. It is admitted that no steps were taken by the appellants to substitute DLRs. Sri Sahul and counsel for the petitioner for the petitioners submits that the LRs of the deceased respondent have a vital interest in the matter, and therefore they may be permitted to prosecute the appeal. Sri N.P. Procedural and counsel appearing for the opposite parties submits that the respondent number 3, there was no proof during pendency of the first appeal that the respondent number 3 had died. He was only not heard of, for which no steps were taken for his substitution. Stop. Be that as it may, having regard to the fact that the LRs of the deceased respondent number 3
appellant number 3, 4, 5.
नहीं three have a vital interest in the matter. This court is inclined to allow the prayer.
On the risk of the appellant.
Certain knowledge कौन खबर
नहीं पुन से कथा हरिवंश तो सुधा
एनल हियरिंग तो
हेलो at the risk of the appellants. At the risk of the appellants. Respond the LRs of where is the schedule? Who are they? Court को election तक विषय detail लिखना थी.
देखिए cause title टा दीजिए appeal रा cause title दे दीजिए.
Court है क्या?
appeal रा cause title 3, 4, 5.
ना अपन ये petition रे court देना
ना petition देने खाली describe कर दे.
किम जानिए ना किम
paragraph 3 petition paragraph 3
LRs of respondent number 3 as described under paragraph 3 of the petition be added as appellant numbers. कितने?
3, 4, 5.
3, 4 and 5. है ना? The matter is otherwise ready.
Not admitted.
आज admit कर रहा है.
Simply admit.
Simply किंतु कर दूँ.
मैं तब तो next week.
Admission भारी कॉस्ट मो कोर्ट रहेगा.
ना ठीक है.
मो कोर्ट एडमिशन भारी कॉस्ट.
से एडमिशन स्टेज
भारी सहज provided that is legal point.
आप किसी कोई
नहीं ताने मुझे कथा कोने से एडमिट ना हमको पूरा मेमो फेमो अपील देना थी.
दोनों थी.
हाँ दे दी.
दे उसे आप एडमिशन अपना करो कौन? मत सर्टिफिकेट कौन दो?
हाँ नहीं मुझे कथा नहीं मुझे एडमिट है ले मतलब कंप्यूटर में
अब काम कर देता है.
With giants like you, with civil giants like both of you, this court will feel very coward. Anyway, no. 1 week after 2003, Mr. Sahu.
Next Tuesday.
Next week commencing year ଆସିବ. This is matter for admission next week. Next week week commencing sponsor.
Only one prayer after lunch.
After lunch ही नहीं आएगा. Weekly list is always after lunch. I can accommodate it. It is for the entire week. To come out of order 41 rule 11. Accommodate. Yes.
So I will pardon. Item 1 was passed over.
Yes.
So I am ready for from respondent side.
ତାହେଲେ ଟିକେ ୱେଟ୍ କରନ୍ତୁ, ଆଉ କିଛିଟା ଅର୍ଡର ସରିଯାଉ, ଆଉ କିଛିଟା ଅର୍ଡର ସରିଯାଉ। ଆପଣଙ୍କୁ ଦିଥର ଡକା ହେଲାଣି, ଆପଣ ନାହାନ୍ତି, ତ ଆପଣ ଯେତେବେଳେ ଆସିବେ ଆପଣଙ୍କ କାମଟା ନେଇ କରିବେ ବୋଲି ସେମିତି କାହିଁ ମତେ କାହିଁ ଲାଗୁନି ହେଲା ଭଳିଆ। ବସନ୍ତୁ ବସନ୍ତୁ।
Item number 5.
Item 5. Pass over.
Item number 6.
A memo at flag P stating therein that sole appellant died on death day for abatement of appeal.
Since 2019.
You are the respondent.
Mine.
So who has filed this memo?
I have.
You have filed this memo?
Yes.
No steps have been taken for substitution?
No.
None appears? None appears for the petitioner, for the appellants on repeated calls. A memo is on record being filed by, where is that memo? Being filed by learned counsel for the appellant that for the respondent that the sole appellant Ramahari Malik has died on 8/8/2019. No steps appear to have been taken. No steps have been taken so far for his substitution. Since there is no appearance today on repeated calls, this court finds no reason to keep the appeal pending, as the suit has already abated. Hello. Is disposed of as such. Item 7.
Item number 7.
May please your lordship.
Yes.
Here respondent number 2 notice has gone on repeated occasions. It has returned back. Your lordship may delete him and proceed with the appeal.
All right. Since Sri S.D. Das, learned senior counsel, submits that respondent number 2, na?
Yes, yes.
Respondent number 2.
You are the member of the managing committee.
All right, may be deleted. Yeah. In view of such submission, respondent number 2 is deleted at the risk of the appellant.
Yes.
Otherwise ready for hearing.
Yes. Otherwise it is fit for hearing. All others have notice has been solved.
All right. Since all of the respondents have appeared and the appeal is otherwise
not appeared. Notice has been. Somebody has appeared on behalf of the respondent.
Well, let us find out. Let us find out. ନା ଖାଲି ରେସ୍ପଣ୍ଡେଣ୍ଟ ନମ୍ବର 2 ପାଇଁ ଏ ପ୍ରୋବ୍ଲେମ ଥିଲା, ବାକି ସମସ୍ତଙ୍କର ବୋଧେ
ଆଜ୍ଞା ଆଉ ସମସ୍ତଙ୍କ ଉପରେ ନୋଟିସ ସବସେଣ୍ଟ ହେଇଯାଇଥିଲା। ମୁଁ ହିସାବ କରୁଥିଲି ହି ଇଜ ଏଜ୍ ଅରାଉଣ୍ଡ 83 now. If I calculate his age according to the available records, he is 83 now.
ଦେଖି ଦିଅନ୍ତୁ ନୋଟିସଟା। ଦେଖିଲି ତ ପ୍ରାୟ ନୋଟିସଟା ସଫିସିଏଣ୍ଟ ହେଇଗଲା ଭଳି ଲାଗୁଛି ସମସ୍ତଙ୍କ ଉପରେ, ଏକ୍ସେପ୍ଟ ରେସ୍ପଣ୍ଡେଣ୍ଟ ନମ୍ବର 2 ସେ ତ ଡିଲିଟ୍ ହେଇଗଲା ଆଉ କଣ।
ଆଜ୍ଞା
mean time ରେସ୍ପଣ୍ଡେଣ୍ଟ ନମ୍ବର 12, 13, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 15 and 16 appeared through advocates Lakshman Pradhan. I think everybody has appeared.
Hello.
Since this my account clear. And the appeal is otherwise ready for hearing. Listed in the week commencing. The next week also, 2007 matter.
As your lordship pleases, as your lordship pleases.
Listed in the week commencing 8th July for hearing. Yes.
Obliged.
8. Please, madam. My honorable Abhinash Rautrai.
Yes.
No instruction, madam.
Okay.
No instruction.
You are for the appellant?
Yes, madam.
No instruction.
I'm about to respond to one.
Second appeal कौन करा? Read petition is even cause of action. Appeal dismissed or dismissed?
Last course last chance ही दिया मैं तो।
दिया था?
हाँ last।
और सीट पे अपन कौन होंगे? Yes, last chance was granted to the appellant to take steps for substitution. When the matter is called up today, learned counsel, ଆପଣଙ୍କ ନାଁଟା କଣ ଆଜ୍ଞା?
ଜଗବନ୍ଧୁ ରାଉତ।
Sri Jagabandhu Raut, learned counsel appears for the appellant and submits that he has no instructions. In view of such submission, the appeal stands dismissed. Yes.
Item number 9.
This is for the appellant. This whole the respondent number 1 died and the substitution is sought for. 3-4 interim applications are there. But I think that this will take up fast. This substitution application may be taken up fast.
केते item रा केते निष्केश number केते?
973 of 2022.
973, yes. When did he die?
Died on. It is within time.
Within time? All right, when will allow it?
Died on 12/7/2022.
This is an application for substitution of respondent number 1, Jyotimoni Ojha, who died on 12/7/2022. It is submitted that the legal heirs of deceased respondent number 1 need to be substituted.
Paragraph
Has the
1.
right to sue survives against them. The detailed particulars of said respondents, said legal heirs have been mentioned under paragraph 1 of the application. Furthermore, the application is in time. Hello? The IA so is therefore allowed. The legal heirs of respondent number 1, as described under paragraph 1, be substituted in his place as respondent number 1A, B, C.
1A.
Yes, table.
The other interim application after their appearance will be taken up by them. When they are not on record.
So now we'll have to, will you be appearing?
My lord, I was appearing for the respondent 1. Now I am died. So I may be served a copy so that I can appeal.
I am sorry.
Let a copy of the appeal memo be served upon Sri Sarnapramana,
Pitambar Behera, P. Behera.
Sri Pitambar Behera, who undertakes to appear for the substituted respondent. List this matter. What a week for a week commencing 15th July. On that we will see.
The rest of the interim application will be.
The remaining interlocutory applications shall be taken up on that date. On the next date. Yes.
Item number 10.
May I please your lordship? My lord, steps for substitution of the deceased parties be taken within 2 weeks, but wrongly listed 1st July 2024. This honorable court order passed 25/24. So my lord, again 2 weeks time for filing substitution.
Notice is sent to be sufficient on this one of in order dated 25/6/2024, respondent number 10 bracket F be corrected as respondent number 10 bracket small g. है ना? Yes, कौन कुछ देखो?
आगे
10 तारीख के जीवो over time. 90 days तो?
हबनी 11/4 11/5 11/6 11/7 हाँ आओ अच्छी
कितने दिन अच्छी 10 तारीख जाए अच्छी हो?
आगे
गोटे दिन तो कटा हो ना?
आगे आगे पढ़ना फाइल कर फाइल करियो पढ़ना
Sri Mr. Leonard Senior Counsel appearing for the appellant submits that the sole appellant died on
11/4/2024
and that he intends to file an application for substitution of his legal heirs within 3 days.
By the after. Yes.
List this matter in the week commencing 8th July.
Yes.
Week commencing week we assume now.
से 15 जुलाई रखना हियरिंग तो होगा ना
ना से वीकली आसीबो वीकली लिस्ट ही आसीबो तापर जोदन आपण हियरिंग देखि ना कोन steps for substitution be taken in the meeting.
Substitution हला पर हियरिंग होगा तो 15 जुलाई को
ना substitution application let us get it ready, let us regularize the matter and then we will fix a date for hearing depending on the
matter
your convenience and Mr. Naik's convenience.
File to
I is there.
Vacation.
That's why.
সেটা ফাইল করতেন আগে
কথা তো সবাই ভ্যাকেশন কো
নেক্সট উইক
Where is the real expression of area dues is there?
Sir,
Current house rent to be deposit করনা
কেস লাগিব স্যার 2014 মସିହା ମ୍ୟାଟର ତ 17 2017 ମସିହା ସାର୍
ସରିବ କିଛି
ଆପଣ ସାରିଲେ ସରିବ
ସିଭିଲ ମକଦ୍ଦମା ଟିକେ ସୁଯୋଗ ମିଳେ ଗଡେଇବା ପାଇଁ
ଆଉ କେତେଟା ଅଛି ଅର୍ଡର ଆହୁରି କୋଉଟା ରିମେନିଂ ଅର୍ଡର୍ସ ୱିଲ୍ ଟେକ୍ ଇଟ୍ ଅପ୍ ଟୁମରୋ ଆଉ ଗୋଟେ ସେଇ ହିୟରିଂ ମ୍ୟାଟରଟା ଯୋଉଟା ଅଧା ରହିଛି ସେଟା ୱିକ୍ ସାରା ଅଛି କାହିଁ ବ୍ୟସ୍ତ ହଉଛନ୍ତି ବାହାର ଯାଏ ଗଲା
13ଟାରେ ହେଇଛି ଗୋଟେ ଦରଖାସ୍ତର କପି ସରକାର ଦିଅନ୍ତୁ ମୁଁ ପ୍ରେୟାର କରୁଛି Leave to appeal that
called out tomorrow. You give the copy today.
Condonation application.
already regularize ହେଇଯାଇଛି
ଆଜ୍ଞା ଆଜ୍ଞା
order 41
ଅର୍ଡର 41 ବୋଧେ ଆଉ ହବନି କାଲି ନବ ଇଟ୍ ଇଜ ଇନ୍ ଦ ୱିକଲି ଲିଷ୍ଟ
ସାର୍ 12ଟା already regularize ହେଇଯାଇଛି ଡିଲେ କଣ୍ଡୋନ ହେଇଯାଇଛି ମୁଁ କଷ୍ଟ ବି ଦେଇ ଦେଇଛି 12 ଆସୁଛନ୍ତି
Admission
ତା ଅର୍ଡର ଡେଟ୍ ଟା ଆଜ୍ଞା ଦେଖନ୍ତୁ
ନୋଟିସ୍ ଅନ୍ ଲିମିଟେସନ ମ୍ୟାଟର ଗଲା ସଚ ନୋଟିସ୍
27/3/23 ରେ ଡିଲେ କଣ୍ଡୋନ ହେଇଛି ମୁଁ କଷ୍ଟ ମଧ୍ୟ 4/3 ରେ ଡିପୋଜିଟ୍ କରିଦେବି ତେଣୁ ଏ ଲିମିଟେସନ ମ୍ୟାଟର ଯୋଉ ନୋଟିଂ ଆସିବ ଦରକାର
since substantial representation principle apply କରି କରିଛନ୍ତି ଠିକ ଅଛି
ନା ଡିଲେ ଅଲରେଡି
କଣ୍ଡୋନ ଅଛି ଆମେ କେମିତି
କଷ୍ଟ ମଧ୍ୟ ଦେଇ ଦେଇଛି ତେଣୁ
since delay has already been condoned and cost
already paid
let's just appeal
next
in the week commencing 8th July you can hearing ଆସିବ ତ
admission
for admission all right yes Mr. Sorangi
item 20
item 20 କଣ urgency କଣ
this is a dispute between the brother and sister
sir notice ଯିବ କଣ delay ରେ ଆଉ କଣ
file କରିଛି execution case the purpose order passed by the trial court but mechanically the appellate court
delay କଣ ରହିକି ମୁଁ stay କେମିତି କରିବି
ମାନେ ଖାଲି read the trial court order
ନା ମାନେ ଖାଲି କହୁନାହାନ୍ତି ମୁଁ delay କଣ କରିକି stay କେମିତି କରିପାରିବି
file a miss case execution
ମୁଁ ଜାଣିନି ଆଜ୍ଞା ମତେ ପାୱାର ଟା ଦେଲେ ମୁଁ କରିଦେବି ଷ୍ଟେଟ କରିଦେବି କଣ ସାଙ୍ଗେ ସାଙ୍ଗେ କରିଦେବି ପାୱାର ଅଛି କି ମୋର ବିଲ ତ କଣ ନେଇ କେମିତି ଷ୍ଟାଟସ୍ କో କରିବି
ସେମାନେ ସେ କେସ୍ ଟା କଣ ହେଇଛି ଟୋଟାଲି 20 acres land ମଦର କଣ କଲା ଗୋଟେ ଝିଅକୁ ଏକ୍ଜିକ୍ୟୁସନ କରିଦେଇଛି ମାନେ
you take notice by if you want you can take notice by special messenger ଜଲ୍ଦି ହେଇଯିବ
ବହୁତ ଗୁଡା ଲୋକ ଅଛନ୍ତି
ଆଉ କଣ କରିବ ତ ନୋଟିସ ନ ଗଲେ ତ ହେଇପାରିବ ନାହିଁ
ଭାଇ ସ୍ପିଡ ପୋଷ୍ଟ ଯାଉ
ସ୍ପିଡ ପୋଷ୍ଟ କରିବ
any coercive action against the
କେମିତି ହବ ଆଜ୍ଞା
ମାନେ ସିଧି order
I cannot pass any order I cannot pass any
will ଟାକୁ void କରିଦେଲେ କହୁଛନ୍ତି you vacate the area
ଦେଖନ୍ତୁ ଏଟା
minor has 151 power is always minor ମାନେ ଖାଲି ପଢୁ ଟ୍ରାଏଲ କୋର୍ଟ ଅର୍ଡର ପର୍ବସ ଅର୍ଡର ପାସ୍ ହେଇଛି ରନିଂ ପେଜ ମାଇ ଲର୍ଡ ରନିଂ ପେଜ 55 ପାଇଁ
ରୁହନ୍ତୁ Yeah.
ବ୍ରଦର ସିଷ୍ଟର କେସ୍ ତ
ଷ୍ଟାଟସ୍ କୋଟା କଣ ମୁଁ ଜାଣିନି
ରନିଂ ପେଜ 55 ମ୍ୟାଡାମ
ମୁଁ କରିପାରିବି
ସେ will ନାମାଟାକୁ void କରିଦେ
I will never go against the statute ଆଜ୍ଞା you come up with a decision showing me that yes you have a power ମୁଁ କାଲିକି ରଖୁଛି ଆପଣ ଆସିବ ଦେଖାନ୍ତୁ that I can pass that order I will definitely pass that order ଷ୍ଟାଟସ୍ କୋ ପାସ୍ କରିବାର କଣ ଅଛି ଡାଇରେକ୍ଟ ଇନଭେନ୍ସନ ଅଛି but you cannot pass that order of stay ମାନେ ଆପଣ ଯୋଉ ଷ୍ଟାଟସ୍ କୋ କହୁଛନ୍ତି ସେମିତି
ମୁଁ ଷ୍ଟେ ଫର୍ଦର ପ୍ରୋସିଡିଂ ମାଗିଛି ଏକ୍ଜିକ୍ୟୁସନ କେସ୍ ର ବର୍ତ୍ତମାନ ଟାଇମ ବିଂ only status code ମାନେ ଝିଅଟା ନା ଭାଇ ଘରକୁ କେମିତି ବାହାରିଯିବ ତମେ ମାଇ ୱିଲ୍ ମେ ବି ୱାର୍ଡ ଯଦି ୱିଲଟା କଟିଗଲା ମା ମଦର ମଲା ପରେ ଭାଇର ରାଇଟ୍ ଅଛି ଭଉଣୀର ନାହିଁ
ୱିଲଟା କେମିତି କଟିଯିବ ଆଜ୍ଞା
ୱିଲଟା ସେ ଭଏଡ୍ କରିଦେଇଛନ୍ତି
ଆଚ୍ଛା ଭଏଡ୍ କରିଛନ୍ତି that will be decided here
decided
decided
all action immediately
ୱିଲଟା effective ହବ without probate
ନାଇଁ ସୁନ୍ଦର ଡିଷ୍ଟ୍ରିକ୍ଟରେ ପ୍ରୋବେଟ୍ ନଟ୍ ମ୍ୟୁଟେସନ ହେଇଯାଇଛି ମ୍ୟୁଟେସନରେ ବ୍ରଦର କନସେଣ୍ଟ ଦେଇଛି ଆଉ ଭଉଣୀ ବାପା ମାଙ୍କ ସେବା କରିଛି ବୋଲି ଆଡମିଟ୍ କରିଛି ଏଭ୍ରିଥିଙ୍ଗ ଆଡମିଟ୍ ବଟ୍
I don't know what is the principle they are following in Sundargarh, but in many areas where even probate is not required, still then the approval of the district judge is required. I think Mr. Mahathi or anybody can. In some areas, I think Mr. Mahathi, some areas even where probate is not required as per the Indian Succession Act, still there is some approval is required or something like that.
Decided by the civil court, probate not necessary. ସେମାନେ କନସେଣ୍ଟ ଦେଇଛନ୍ତି ମ୍ୟୁଟେସନ ପଟା ମୋ ନାଁରେ ଆସିଛି ମୁଁ ପେଇଂ ଖଞ୍ଜଣା ଦେଇଛି ବଟ୍ ଟ୍ରାଏଲ କୋର୍ଟ ପାସ୍ ହଳ
ନୋଟିସ ନିଅନ୍ତୁ ନୋଟିସ ନିଅନ୍ତୁ ନୋଟିସ ତ କେବେ ନିଅନ୍ତୁ ଆଉ କିଛି ହବନି ଆଉ କଣ ଇସ୍ୟୁ ନୋଟିସ ଆଇ କେତେ 1475 है ना you can file an affidavit in the court below for stay of the execution proceeding on the ground that the appeal has been filed and notice has been issued on the question of limitation. That is your remedy. You can move it. Thereafter, maybe
notice of both which cases have notice.
Issue notice to the respondents by speed post, fixing a short returnable date, requisites be filed by tomorrow. List this matter.
So in the week commencing 29th.
In the week commencing 29th July.
My lord, Mr. 669 by 24 भी जाओ notice.
Issue notice कर दो किसी को. Notice as above. Yes.
No. Difficult file by day after tomorrow.
Day after tomorrow. Got it. Requisites filed by day after tomorrow. है ना? कौन कहले कौन अच्छी ना
मिस्टेक्स अच्छी
अच्छी ना दीटा मिस्टेक्स अच्छी देखो मतलब ये फाइल अच्छी है कॉल यस କାଲି ନା ସେ ଗୋଟେ ହିୟରିଂ ମ୍ୟାଟରଟା ରହିଯାଇଛି ପାଠର ମୁଁ ସେଥିପାଇଁ ଦିଦିରେ ପାଠର ରଖୁଛି ନହେଲେ ଇଏ ସରିବନି ଆଜ୍ଞା Mr. Das, you had practically concluded excepting for one or two that section 34.
I'll just repeat it for 2-3 minutes because my learned friend was not there on the other day.
Yeah, now is he there?
He was not there on the other day.
Yes.
When the matter was taken. Defendants are the appellants here. And the appeal is against the confirming judgment.
अरे ମୁଁ ଲେଖା କିଛି ଅଛି ଦେଖିଲ ମୁଁ ନୋଟ୍ କରିଥିଲି ବୋଧେ କଣ sir?
And then it is against the confirming judgments. Plaintiff prayed for a declaration of title, confirmation of possession, then a right of repurchase,
yes,
and permanent injunction. All in one suit, these prayers were there. Learned trial court granted decree of permanent injunction alone. All other prayers were refused. That has been confirmed. Facts of the case would show that in fact the plaintiff and defendant numbers 2 to 5, they were recorded in respect of a choco. Defendant numbers 2 to 4, they alienated in favor of defendant number 1 about a particular extent of land, that is 1/3 share in that land. Plaintiff said that I am in possession of the property. I have been paying 1/3 share in the usufructs, that is the plain government, to the defendant numbers 2 to 5. With that prayer he came up. Ultimately, finding was arrived that since it created a fragment, there has been an infraction of the provision under section 34. The sale deed is void. So therefore, permanent injunction was granted against the defendant number 1. This has been confirmed in the appeal. Now, in the present second appeal, it has been admitted on 2 grounds. Firstly, whether a notification under section 41 was published by then. That is the first ground. Second is that presumably that word has been used by this honorable court. The suit is hit or barred under section 51(2) of the Consolidation Act. These are the two grounds. On the first question, my submission would be that if your lordship will look at section 33, because all these are in chapter 5 of the Act.
Just before you proceed, since you were talking about that amendment provision, I'll come on why I'm saying it. Shall we frame an additional question?
That your lordship has to frame it.
So that he will get notice to argue on that point also.
Your lordship.
I think the state is also there in this case.
No, state is not.
State is not.
State is not there. We will frame that. Formally frame kar do.
Well, first, your lordship may kindly see chapter 5. I'm reading out loudly.
Yes, please.
Chapter 5, it heading prevention of fragmentation.
Yes.
It was there earlier. Section 33, application of this chapter. This chapter shall apply to an area in respect of which a notification under section 41 has been issued. Here the contention of the appellant should be that plaintiff, while coming to institute the suit, did not say that there was any notification under section 41 of the Act, so that other provisions under this chapter will have any application. Because if the claim is that the transaction is hit under section 34, then at least the learned courts would have also taken care to see that whether any notification under section 41 has been issued. Then you will also may see section 51(2). There also we may keep section 9 of the CPC in view, that unless and until it is expressly
ouster of jurisdiction.
barred,
Ouster of jurisdiction.
yes, civil court shall have jurisdiction.
Yes.
So there the question is that how far this defendant who says that the court has no jurisdiction has been able to establish this. Language of 51 is bar of jurisdiction of civil courts. Then 51(2), the specific thing that has been observed in the substantial question, no civil court shall entertain any suit or proceedings in respect of any matter which an officer or authority empowered under this Act is competent to decide. So if for infraction of section 34, the collector is vested with the power under section 35, then the suit would not be entertained. There is a clear bar under section 51(2), therefore the suit is incompetent. But now, even leaving aside all these points, section 34 and 35, that has been omitted in the statute by virtue of an amendment which came into force in 2023 amendment. By virtue of which section 34-35 has been omitted, section 36A has been inserted.
Validation.
Yes, my lord. There the language is about the validation. Any transfer or partition of agricultural land in a locality creating fragmentation under the Principal Act before the commencement of Odisha Consolidation of Holdings, Prevention of Fragmentation of Land Amendment Act 2023 shall be treated as valid. So this covered all such transactions which were held earlier to amendment by which fragment was created to be valid, subject to the further rider, provided that cases where any eviction has been made by the collector under subsection 2 of section 35.
সেটা রিওপেন হবে না?
35 is the remedy. If somebody has availed the remedy and by the order of the collector something has been done, that will not be reopened. Other than that, since it is a pending proceeding, I will also get that judgment, one of the judgment of this Honorable Court, that is in RSS 7 of 2024, which has been recently decided by Justice D. Das, Honorable Justice D. Das.
Yes.
Taking note of this 36A, my lord has observed that it applies to all such pending proceedings, and by 36A will validate all such invalid transaction even if that has been done. So if 36A is applied, then the findings which are there in the record, that obviously goes. Transaction is valid. The only reason that the transaction is invalid, that is why a permanent injunction. Otherwise, somebody who had the right, he has alienated the property. One other thing also arose in this case, which I had framed a question, which is not framed by this Honorable Court. Here, what has happened, it is only 46 decimal, the total land, the extent of land, out of which 15 decimals only sold, 1/3, nearly 1/3. So 46 was really a fragment. So how to say that a fragment is created? It is originally a fragment. So the question is that if the holding is a fragment itself, whether section 34, but now that question also need not be framed on the face of section 36A.
Yes.
I have got a small note.
That judgment you are referring to of Justice Honorable
I
Justice.
will pass it on.
Yes.
7 of 24, I will give that judgment.
Yes.
Lords. Lords, so this is a purely concurrent finding of fact, and the issues that have been framed by the Law and Trial Court are 4 issues. The vital issue is issue number 2, to whether the transaction done between the vendor and vendee is void or void ab initio. So it has been held by the Law and Trial Court that the transaction which was done by making fragmentation as per section 34, which is in the violation of the Act, that is void. It has been clearly held by the Law and Trial Court. And so far as the new amendment act has come into force, so whether it is applicable to this appeal or not is a matter to be thought of and also to be checked, Your Lordship. Whether it has any retrospective effect or not, I will, Lordship, verify. Subject, another thing is that a judgment that is RSS 7 by 2024, Your Lordship, I have not checked out. If I will be permitted, I will see and whether it has any retrospective
No,
effect.
the thing is, let us see. Let us read the act together. Yeah, 39.
Three amendment.
Yes, 39. You have seen to the language itself suggests a retrospective operation, because it says well, before the commencement of the Odisha Consolidation of Holdings Amendment Act. মানে এই যে amendment আসিলা যেহেতু, so মানে before this amendment came, any transfer or partition shall be treated as valid.
In respect of fragmentation, Your Lordship.
Yes. This is under chapter 5. Chapter 6 actually.
Should you verify?
Alright. Because it says any transfer or partition creating fragmentation, which is here the case. Earlier it was, so permission was necessary under section 34. 34 code. No. 30 to say provisional omit ho gelani. So 33 and 34, 33, 34 and 35 consequently have been repealed. It's a different matter that according to Mr. Das, it probably the virus may be challenged.
If there is no saving clause, Your Lordship.
Saving clause, এই case রে কিন্তু রইব। See, deliberate policy decision, probably the government took a decision, the state rather, that this is creating all sorts of problems. মানে fragmentation ପାଇଁ ପଡିଗଲା ହେଇଗଲା, ସେ ସବୁକୁ valid କରିଦେଲେ। ସବୁକୁ valid କରିଦେଲେ। So this will apply.
The very purpose of the act is now defeated.
One can say, one may say that. So if you validate it, then now anybody can create a fragment. So if
Chokko that would be carved out, ultimately if it is fragmented, then what?
I was on that day, therefore I openly said that I will rather refer to the other substantial questions of law, if possible. But now he has got a very valid right to raise this aspect because this is very
fragmentation was always permissible
with
subject to permission by say yes.
And that was usually being done by backdoor, that to prevent that.
No,
this has been done.
This
has been being done.
That is different.
So we'll keep it to.
My lord, may I kindly have
না খালি পরদিন ভিতরে কই দেবে সর্বনিম্ন ম্যাটারটা
শুক্রবার ইচ্ছে নাই খালি
তাহলে এটা একটা কাম করব এটা খালি জাস্ট পাস ওভারিক রইলা টিক মারতাম উইল কল ইট অন ফ্রাইডে কেতে 12 তারিখ 5 তারিখ আছে
Friday, Your Lordship, on Monday, next month. Monday.
তাহলে ভালো না টিউজডে মানে ইয়ে আসিব না heard further arguments in this matter in the week commencing 8th July.
The very same place.
Yes.
At Jaipur.
Yes.
Going on 6th. Or matter fixed on 6th.
No,
so
but
I'll be in a hurry on 5th to get wind up.
8th July it will come to, it will be for the entire week.
Yes. All right. Here also, my lord, if Your Lordship permit, I've got it. That 7 of 24.
Oh, yes.
My lord, it is well nigh the settled position of law that change in law after the disposal of the original proceedings can be very much taken note of in the pending proceeding arising out of the original proceeding. That being so, in view of coming into force of the OSCH PFL Amendment Act 2023, by omission of Chapter 5 containing Section 34 and 35 and introduction of Section 36A in respect of the provisions contained in Chapter 5, having the nexus with the provisions under Section Acts, Deeds and Effects, by virtue of those omitted provisions, the submission of the learned counsel for the appellant has no legal base to stand upon. Therefore, even upon saying.
Let us frame a question.